Can you hear me?
Yes.
It's telling me that I'm not on Zoom right now. I did do this yesterday. It doesn't want me to just take Zoom today. It's booting me out. Got it. Try this again. Okay, I think we got it covered. So let's see for David Chaney. Representing David Chaney. Okay. Okay, sounds good. And then Walker. PCC. Alright, okay. Good morning. Wallace. Okay, we're on the record in the matter of the people of the state of Michigan versus David Keith Chaney, file number 22-02357. Can I have your appearance, counsel?
Yes, Your Honor. Good morning, Assistant Public Defender Stephen Feigelson, appearing on behalf of Dave Chaney, present by Polycom this morning.
There's Chaney's date that was scheduled for sentencing. I do have a pre-sentence report and recommendation. And did you receive a copy of that?
I did, Your Honor, and Mr. Chaney, I did go over that report.
And you need to make corrections, updates, deletions?
None, Your Honor.
Okay, you can do allocation.
Yes, Your Honor. He's been in jail for 54 days, Your Honor. They are recommending probation. As the court may be aware, he does have a pending matter up in circuit court on a failure to pay child support. Couple that I believe he has some outstanding matters in Clinton County. What I'd ask for is given credit for the 54 days served and placed on probation up in the circuit court, assuming there's a conviction on the child support. So we just ask for the credit for the time with no probation today, Your Honor. Thank you.
Okay, he pled guilty to one count of use of methamphetamine, and he had a assessment done, which he did meet a criteria for a moderate stimulant amphetamine type use disorder. It was recommended that he also have some outpatient, and so you don't think that use of methamphetamine needs to be addressed, and he just should get
Well,
credit?
it may very well be addressed when he goes on circuit court probation, assuming that happens on the failure to pay child support.
I don't know why they would address that without doing the transport.
Sometimes they do, depending on the report.
Does he dealt with the other 4 warrants that were listed in this report?
I don't believe he has, but Mr. Chaney, have you dealt with warrants out of Clinton County yet?
No, I was unaware of one in Clinton County.
Said you had a warrant issued in 65A district court for failure to appear. There was a pickup for 100-mile radius. There's a warrant for 56A district court, another warrant, or 2 other warrants, 56A district court. So you have a total of 4. But it looks like it's only 2 different courts, okay?
Okay.
You're gonna probably want to deal with that. What's going on with this one? You did have a moderate, or did score moderate for the criteria for use disorder. It looks like in the other domain, overall, he was moderately low. He has been in custody for 54 days, and then because of all the other things that he has going on, I just don't see how he would be able to be successful on probation here. Hopefully, they'll address any underlying issue if it's necessary. With the felony probation, if he does end up on probation for that, for the child support. I would imagine that they would see his recent criminal history and have him screened if necessary for appropriate programming. With that being said, I will give him credit time served and close the file. Any additional matters for the record?
None, Your Honor, thank you.
You're all set, sir.
Mr. Chaney, I'll be in touch on the other matter as soon as we get in the court date.
Okay, so there's still no court date?
I don't believe so. I'll double check and I'll give you an update when I get one, okay?
All right, thank you.
Yeah. Randy helped me out today.
He's my babysitter.
Not my babysitter.
Don't say that. What's the guy's name? Oh.
I like to call things that makes everybody uncomfortable when I call him my babysitter.
It's just kind of funny. Randy, my friend.
I don't know if he thinks it's funny. He's ready to stop. He's ready for those bar results to come out just as much as I am.
Yeah.
It's almost November, so they gotta be coming soon.
I actually think Thanksgiving, so.
This morning, actually, I was looking for a pair of boots and I found my Ziploc bag that had all of my stuff that I used to take the bar. Because I never threw it away. Okay, Mr. Davis.
Good morning, Your Honor.
Good morning, you're here for Jada Wallace.
Yes, I am. We're ready.
Okay, we're on the record in the matter of the people of the state of Michigan versus Jada Lene Wallace, file number 22-02193. Have your appearance for the record.
Good morning, Your Honor. I'm Reese Davis, P76203, appearing with Jada Wallace, who's present and appearing via Zoom. We're ready for sentencing. Ms. Wallace, we unmute. State your name. You have to unmute.
Oh, Jada Wallace.
Okay, and how are you, Ms. Wallace?
I'm doing fine.
It was the date that was set for sentencing, and I have a pre-sentence report dated for October 14th. Did you get a copy of that, Mr. Davis?
Yes, I did. I had an opportunity to review it. My client reviewed it as well. It's factually accurate. No corrections, deletions, or additions.
Okay, sounds good. You can make allocation at this time.
I would like to point out my client, she's 21. This is her very first negative contact with the criminal justice system. No other criminal history at all. There was a agreement of HIDA. We just asked the court to follow that agreement. I think it's appropriate given my client's overall background and everything. See, the recommendation is a 6-month term of HIDA probation. I believe it's appropriate. Would ask the court to adopt that.
Okay, thank you. My records reflect that there was no objection to HIDA. Our prosecutors do not tend to enter an agreement as to HIDA.
Okay, I misspoke. Yes.
Okay. It does say in the report that she scored moderate high in the need for leisure activities, but low in all other domains. It sounds like she's appropriate for HIDA status. Don't see anything else sticking out. Because of that, I will put her on a term of probation and grant status under HYTA. She will be placed on a term of 6 months probation. Ms. Wallace, while you're on probation, you have to make sure you do not engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to use, purchase, or possess alcohol, marijuana, or a controlled substance unless you have a valid prescription. Do you understand that?
Yes, ma'am.
You are going to be required to submit to random preliminary breath test and or your analysis. You also have to pay the fee that's associated with that, okay?
Okay.
You're not to be at any bars or nightclubs while on probation. Do you have any questions about your terms at this time?
No.
You're currently employed?
No.
Okay, you're gonna be required to obtain employment during this 6 months of probation. Do you understand that?
Yes.
And you'll have to provide proof of the employment to your probation officer.
Okay.
While on probation, there's a $30 per month oversight fee that you are responsible for. Okay, and then as to additional fines and costs, there's a $75 crime victim rights fee that will be assessed, a $50 state minimum cost, 6 months of probation, excuse me, will amount to $180. I'm gonna waive discretionary fines and costs at this time because you will be paying to do PBTs. And you're not employed at this time, so that's a total of $305 in fines and costs, and you will be able to make monthly payments. You'll get a phone call to meet with probation, and they'll go over this order, and they'll explain to you, you'll probably be making a payment of about $51 a month, okay?
Okay.
Okay, last but not least, I have an advice of rights for probation early discharge. It says you have been sentenced to a term of probation in the 54A District Court. The probation conditions have been individually tailored and are specific to address your assessed risks and needs, except for in cases of domestic violence, criminal sex crime, stalking, or an offense where the defense of guilty but mentally ill was asserted. You may be eligible for early discharge from probation. You have the following rights. You have the right to request early discharge from probation once you have completed half the original probation term ordered by the judge. Your probation officer may, but is not required to, file a notice with the judge once you become eligible for early discharge. The probation officer must send to you and the prosecuting attorney a copy of the notice. The prosecuting attorney then has 14 days after receipt of the notice to file a written objection to the request for early discharge. You may request an early discharge from probation after meeting the following conditions. You have completed all the required probation programming and you have not violated probation in the 3 months prior to your request. You must send a copy of your request for probation early termination to your probation officer and also to the prosecuting attorney. The prosecuting attorney will then have 14 days after receipt of the notice to file written objections to your request for early discharge. If a hearing is scheduled to address your request, you would have the right to hire. You have to hire or retain an attorney, but you do not have the right to court-appointed counsel to represent you if a hearing is scheduled. You may make your request for early discharge by completing the notice regarding eligibility for early discharge from probation. That's called the MC 512 form, and that form is located on the court website. Do you have any questions about that, ma'am?
No, ma'am.
Okay, so I'm placing you on a term of 6 months. I'm not giving you any programming, but you are required to obtain employment. After 3 months, if you can provide proof that you are employed and you have not violated the terms of your probation in those 3 months, then you can submit a request if your probation officer does not for early discharge, okay?
Okay.
Okay. Do you have any questions about probation or fines and costs or anything else at this time?
I did have a question. You mentioned something about stalking.
Yeah, I said unless you were on probation for stalking, so that doesn't apply to you.
Okay. I just wanted to ask.
No problem.
That's all.
Okay, any additional matters for the record, counsel?
Oh, I'm sorry, Judge.
I was asking if you had any other matters for the record.
No, nothing else, Judge. Thank you.
Okay, very
We're all
much.
set.
And good luck, Ms. Wallace.
Okay, thank you. Have a good day.
You too. Mr. Walker. You guys have an attorney? On the record in the matter. I don't have a prosecutor. Mr. Walker, can you start your video, please? I'm just waiting for a prosecutor to come back in here so I can go on the record. Andres Morgan was supposed to be sentenced. Did not appear.
Do you want me to stay muted?
Yeah, you can stay muted at this time. Oh, okay. On the record in the matter of the people of the state of Michigan versus Dayon. Did I say that right?
Dayon.
Dayon Walker. This is file number 22-02268 FT. Have your appearance, Kristen.
Brian Rang on behalf of the people practicing under Michigan Court Rule 8.120. My supervising attorney is Randall Byrne.
Thank you. And Mr. Walker, today was the date that was set for a preliminary examination. I said I was going to treat this as another probable cause conference because you had not been appointed counsel. I was notified today that you were denied court-appointed counsel. Were you made aware of that, sir? Mr. Walker? You have
Oh,
to
sorry.
unmute now.
Sorry, I was still muted. No, I was not aware.
Okay, did you ever provide information that they requested about your new job?
Yes, ma'am.
Okay, well, it sounds like that they've denied you based on that. So you're gonna need to either hire an attorney, you can try to appeal the denial and have them review that if they request additional information, or you're gonna have to proceed without counsel. So do you want to try to appeal their denial, sir?
No, because I mean I do have a job now. Like I did just start the job and barely got paid, but I guess I'm gonna have to try to buy me a lawyer.
Okay, yeah, if you want to retain a lawyer, we can adjourn this and get you some time so that you can get counsel, okay? So it looks like you were arraigned on this matter back. Yes, sir.
I have a baby that's gonna be here on November 4th, and we are not going through it at all. Like this is gonna be prolonged. Obviously, I can tell because this is 2 court dates now, and like we love each other. She got her car back when it happened.
Okay, let me stop you. You have the right to remain silent. Anything you say
I do have the
can
right.
be, wait, yeah, I stopped you. You have the right to remain silent. Anything you say can be used against you. I have prosecutors here. I'm on the record. We're going live. I have to stop you from disclosing facts about this case at this time, because right now we just really have to address whether or not or how we're going to move forward. So do you want an opportunity to hire an attorney, or do you want to waive your right to counsel and meet privately with the prosecutor about resolution? That's up to you. And I recognize you have a child on the way. I was going to address the timeline so that we can reset this so that you can have time to get counsel to represent you on this, which I believe you need counsel. But that's up to you how you want to proceed. I have no problem resetting this matter after I address the timeline to go beyond the time in which you're going to have your child, so that doesn't conflict with the birth of your child, sir.
Yeah, I'll buy a lawyer.
Okay, so you have the right to have a preliminary examination within 21 days of your arraignment. You were arraigned on October 12th, 2022. Your examination was scheduled for today due to the fact that you were denied public counsel. I'm assuming because they're stating you're not indigent. I am going to find good cause to go beyond the 21-day timeline. I'm going to reset this a couple of weeks out so that you can have time to get in contact with some attorneys and see if you can retain one. And also because you're going to have a baby, it looks like next week.
Okay.
Do you have any questions at this time, sir?
Nope.
Okay, let me get you new dates right now. Sorry?
I saw Adam running toward Buchanan. I don't know where he's at.
Your new probable cause conference will be December 2nd at 8:30.
I don't know what that is.
Um,
Okay, probable cause conference is actually going to be December 1st at 8:30.
And then exam December 9th.
Your exam is going to be December.
December 16th,
December 16th. At what time?
8:30.
At 8:30. The exam will be in person at the court. Okay, and if you hire an attorney, they can address any timelines if they have conflicts with that time, okay?
okay.
Any questions?
And this whole 3 months I gotta stay on this tether.
So you're requesting to address bond?
Yes, ma'am. I go to work 6 days a week, and I have 2 daughters already. I watch one of them every single day. Like I don't know. It's just I don't know.
Well, I have no problem removing the tether. I'm trying to understand why there was a GPS tether.
He said because I don't know if he felt like it was the first judge who arraigned me. It felt like it was like a domestic or something, but he also told me it would be free, and when I left the jail I had to pay for it, and then I finally it took them a long time to accept my Medicaid, and finally they accepted it, but they said I couldn't get my money back.
You're on Medicaid?
Yeah, and I needed to get out the very next day to keep my job, and so I had to pay the money where they weren't accepting my Medicaid at first. Like I kept telling them, I tried to show them when I left the jail, I tried to show them my Medicaid card. They took my money.
Okay. Did you let the public defender know that you was on Medicaid?
Yes.
Okay. I will amend your bond to remove the GPS tether.
Thank you so much.
And since you're here, you also have a failure to appear warrant here.
Do I have to go back to sitting in the holding cell to fix that, or can I just come pay? Because it was just restitution fees, I believe, that I have a failure to appear for.
Yeah, I'm gonna address it right now. This is the matter of the people of the state of Michigan versus Dayon Walker, file number 18-05531FY. Looks like you were before Judge Ward back on January 12th to address the issue of restitution. And it looks like you were supposed to be making monthly payments, but you stopped.
Yeah, I just I was trying to find work, and it's hard with these babies, but now I work 6 days a week. I can make the payments every week or whenever, and yeah, I plan on
When you gonna
paying
make
it
your next
all off. Next week I get paid, and I can make a pretty large payment.
Note here that you'll get back on your payment plan next week. Do you have any questions?
No, ma'am.
Okay, and then
So is the
you-
warrant?
you
Do I
can go
still
and
have the
your
warrant?
tether. No, I just addressed the warrant.
Okay.
So you're all set on that. You can go and get your tether removed on the pending file, okay?
Okay.
Okay, and then we'll see you on December 1st.
December 1st.
December 1st.
Thank you so much. You have a great day.
Same to you. Andres Morgan failed to appear. Juarez is in. Vincent Juarez is in custody. Are we running an exam?
I don't believe we are. Mr. Palmer's on that. He's out here in the hall right now.
What about Hoffman?
I haven't spoken to Mr. Goodrich this morning. I think he was speaking with her. I know she's here.
Then TV. I mean, it's been hours. Everybody had plenty of time to talk now.
It's going to be waived, but again, it's Mr. Palmer.
Okay, well, let's see if they're ready to do some things. Because I'm pretty sure I have a state bar meeting today. Let me see. I didn't put it on my count. It's probably not long, but. Let's see.
Report to the criminal office.
Where?
Report is in the criminal office.
Oh, boy. Judge, so you're for sure taking off? I'll do that. Let me see. Roberts. Is it today Thursday? Oh, maybe. Today's not Friday. They need to send me appointments. Don't send me emails like this. Are we doing PCCs tomorrow? That's going on? Yeah. Okay, because it's set for 9 o'clock. Let me see. And I think we're doing. You ready, Judge? Hey, Judge. Hi, how are you?
We just, in this Hopkins case, we would like to waive today and leave next week, Saturday.
To bring him up.
I'm Tuesday, I made it, yay. I'm sorry?
I made it, yay.
You have to overcome something to get here?
No, I just had, you said you better make sure you come, because otherwise you're not gonna be,
Oh, yeah.
liking the next thing. I said, yeah, I made it.
Writing an exam?
So please.
No.
Okay, yep. we can do that. Okay, on the record, in the matter of the people of the state of Michigan versus Sarah Hoffman, file number 22-02721, council appearance.
Randall Berman on behalf of the people.
And Luke Goodrich from the Public Defender's Office, here to represent Ms. Hoffman, who is standing to my right.
Okay, well, we're really happy that Ms. Hoffman made it. And it was the date that was set for a preliminary examination. How are we proceeding on?
Your Honor, it's my understanding that your defense wishes to unconditionally waive the right to have a preliminary examination in this matter. The people also unconditionally waive their right to have a preliminary examination in this matter. And it will proceed to circuit court for further negotiations and possibility of other files to be wrapped up with it at the same time. Thank you.
That is correct, Your Honor.
Okay, Ms. Hoffman, you understand that you have the right to have a preliminary examination on this matter here in the district court. Yes, ma'am. You understand that at the time of examination, you have the right to have the prosecution meet their burden to establish sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You understand that?
Yes, ma'am.
You wish to unconditionally waive that exam today?
Yes, I do.
You understand the unconditional waiver means you can't come back later and say, you know what, I want to have my exam. Waive it, you can't get it back.
Yes, I know.
Okay, is any promises being made to you to make you want to waive your exam?
No, ma'am.
Is Mr. Goodrich threatening you at all?
No, ma'am.
Okay, is anybody threatening you?
No, ma'am.
Okay, and you're waiving it freely and voluntarily?
Yes, ma'am.
Days are all running in together for me now. Today's the 27th. Tonight. Okay, I'm gonna bind the matter over. Your bind over date is November 9th. You do not need to appear in court on November 9th, okay?
I do not need to.
Do
I can
not.
By Zoom.
No, yeah, you don't have to go at all.
Okay, cool.
Yep, that's just the date they get the file from this court, unless for some reason Mr. Goodrich wants you to have another arraignment over there.
I
And
hope not.
I don't think he does.
I don't think so. either. I don't want another bond.
Yeah, after that, they'll send us a-
Okay.
Yeah, so you'll get the new date. It'll be a pre-trial. And you stay in contact with your attorney, okay?
Okay, thank you so much.
No problem. Bond was 5,000 personal recognizance. That and all other conditions will continue. Any additional matters for the record, counsel?
Your Honor, we would just like to she's set for a PCC with you tomorrow. And we would just like to let the court know that we want to leave that matter set for exam.
Very good. We will know that that one will continue to exam, so that we don't need to
Be here tomorrow.
deal with that tomorrow. Yeah, that
Thank
works.
you.
I actually have a 9 o'clock meeting for the state bar anyway, so as much as possible,
Heck of a deal.
I need.
A good deal. Works out for both of us then. All of us.
All right, thank you, Your Honor.
Thank you.
Thank you.
Have a good weekend.
You too. Actually, hang tight. Let me get you to sign this. since
Oh,
you're
yeah,
here.
you gotta sign it for it.
No, I'm gonna have you sign this. Thank you.
Yeah. You have to sign
Yeah, it shouldn't even be, oh, for the PCCs, for you, yeah, I don't see why you even need to be in person. And at 9 o'clock, I gotta do what? Zoom meeting, I guess. So do some nominations or something for the commissioners.
No, we should be all set.
You guys have a good day.
You too, ma'am.
Thank you. You wanna get the number? You wanna get the number? Wait, do we need to do it?
Docket. Yeah, that's what I was looking for right now.
If you could email me that, if you said, I can get it. That way I have it. Okay. Thank you. We'll see you later.
Morning, Mrs. Neal.
Good morning, how are you?
I'm wonderful. How are you? Is your turn? Is your client here already?
Yeah, he's out in Holland.
Have we done anything on the Mr. Morgan's case, sentencing that was scheduled for 8:30?
A bench warrant.
Okay, you already did.
No problem. Mr. Tyson, what are you waiting for? Venegas?
So I guess I think that's gonna be a Nolly process, and I think we're just waiting on this. Higgins on, legal. That's where she's on her way, but they can.
Oh, yeah, Cleveland's in custody, right?
Yeah, he's here, we're just waiting on Miss.
No, it's not. It's perfect. It's not cold. Don't do that. Shit, they've been blazing us out here.
I know. I love the
Yes, I will.
Yeah.
I remember that.
Okay. I'm just trying to fill out plea sheets right now.
Don't worry, Randy, I'm not going anywhere, I'll make sure.
Okay, what are we doing with Phoebe?
I believe PV's gonna be a waiver, but Mr.
Mr.
Palmer
Palmer, okay.
is out there talking with somebody again.
What matters, Mr. Piper?
Okay, yep, that's fine. I get it.
My sheet's been for. I had everything wrote down on it.
Okay.
Somewhere in
Yep,
this. I'm
that's fine.
trying
Take your time.
to do 3 other plea sheets
I
right now.
understand.
So I'll give him that here in a second. And grab. Once I clear this stuff out, I'll probably find it.
Mr. Piper's on Cleveland.
Mr. Piper will be helping me with.
He's not on Cleveland?
He is.
That's what I thought.
Gonna do double duty today.
Chill.
Ernie Banks over here.
Now, did you have a good week of listening to jail calls? Or?
Yeah, 100%, yeah.
I don't doubt it.
I'm starting to enjoy it now too.
See how we see. Mr.
I'm not sure. Sorry, what's your name? This is Mr. Peavy. Oh, I thought you was going to this one. I did.
Yeah, Mitchell was right. This wait a second. Yeah, that's what I love for it too. So I didn't say anything.
What's going on, Nate? What do you got this weekend? Penn State.
Penn State.
Yeah.
Whoa.
That should be a competitive one. That was what Michigan did to them. Yeah. Well, they always play as hard.
Who do you want to do first?
They're talking about 17.
Mitchell and Flores.
What's up? Said they're talking about the team.
We'll have to-
That's-
All right. Mitchell's ready. That's Mr. P.
On the record in the matter of the people of the state of Michigan versus Vincent Juarez, file number 22-01987 FY, council affairs.
Brian Rang on behalf of the people. And thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Flores, the gentleman who's seated to my right.
How are you, Mr. Flores?
I'm doing good, and you?
I'm doing pretty good. Today's the date that's set for a preliminary examination. Mr. Farmer, how are we proceeding?
Thank you, Your Honor. This appears to be a misdemeanor plea that we will resolve this matter with. You're just, judge just doesn't, court knows, we're just finishing up the paperwork. He was just brought up. I know you guys prefer that. If you were, you could, thank you.
That's what we did. We finished the waiver report. We did a waiver on it. They already did. Thank you. Okay. I have a plea sheet here. It says the people are offering for Mr. Flores to plead guilty to an added count 2 of use of methamphetamine. It's a misdemeanor, maximum penalty 1 year and or $2,000 and sentencing under 7411 if otherwise eligible. That's complete and accurate understanding of what your plea offer is, sir.
Yes, ma'am.
You want to accept it?
Yes, ma'am.
I have a plea. I'm sorry, advice rights and plea information sheet here with today's date on it. That's your signature.
Yes, ma'am.
You read this document?
Yes, ma'am.
You understand the rights listed here? Do you have any questions about these rights?
I know.
Okay, I understand that you have the right to proceed to trial in this matter.
Yes.
I understand that you'd have to give up your trial right in order to accept this plea. It means you're also giving up your right to be presumed innocent until proven guilty. You'd also have to waive your right to see, hear, or question any other witnesses the prosecution intends to call. You're gonna waive your right to call your own witnesses or present evidence at trial that you believe would further defense of this charge. You're gonna waive your right to remain silent and not have silence be used against you at trial. You're also gonna waive your right to have the prosecution prove each element of the charge being brought against you beyond a reasonable doubt. You understand that? We like threatening you to get you to waive your rights today.
No, ma'am.
Are there any promises being made to you that made you want to waive your rights?
No, ma'am.
Are you currently on probation or parole?
No, ma'am.
You understand that a guilty plea can result in a conviction that you may need to report to your current employer?
Yes.
You also may need to report a conviction on future job applications. You understand that a conviction can also impact any immigration status you may be seeking. Are you still understanding that one waive your rights?
Yes.
Okay. Are you pleading guilty because you believe you're guilty?
Yes.
As to added count 2 of use of methamphetamine, how do you plead?
Yes.
Could I have a factual basis, please?
Mr. Flores, I'm going to take you back to April 10th of this year, 2022. On that date, were you at or near the intersection of Larch and Oakland?
Yes.
And as far as you know, that intersection or that location is within the city of Lansing in Ingham County,
Yes.
and that is within the state of Michigan. Is that right?
Yes.
And on that date and at that location, you came into contact with law enforcement.
Yes.
And at the time you came into contact with law enforcement, you were in possession of methamphetamine. Is that right?
Yes.
You knew it was methamphetamine,
Yes.
and you did not have any valid prescription or anything to have that methamphetamine. Is that correct?
No.
I believe that satisfies factual basis.
Any questions from the prosecution?
No, Your Honor.
If the court is satisfied with the factual basis, I'll accept your plea. I find your plea to be freely, voluntarily, and intelligently. This matter is going to be set for sentencing on Friday, December 16th at 1 p.m. We need to meet with probation so they can provide the court with the pre-sentence report and recommendation. What is he being held in custody on?
Thank you, Judge. I was just about to address that. Mr. Flores, as I understand it, he has a couple of matters pending, Judge. He has, as far as I know, he has 2 other misdemeanor assault matters that are currently scheduled or set before this court. I believe they're set according to the notes. They're set for a final pretrial, I believe, on November 8th. He's also on bond in this matter. His bond, I believe, is 4,010%. I would ask that the court consider a reduction in this bond. I realize that the 2 misdemeanor files are not before the court today.
Mr. Ring?
Yeah, I would just leave it to the court's discretion.
Thank you. Where would Mr. Flores be residing if he were to postpone?
Your Honor, he has an address which is the 831 North Capitol Avenue here in St. Louis.
Okay, what's his phone number?
His phone number, at least as he reports to me, is 517-624-9986. I guess I can't personally say that I verified that because he's been in custody my entire representation.
That's your phone number? Your phone works? Okay. I'm in the bonds, 4,000 personal recognizance. You need to make sure you report to probation within 48 hours of your release from custody so that they can set you up for a pre-sentence interview so they can prepare a report, okay?
Yes, ma'am.
We'll get you a referral. You also need to make sure you appear to court for your sentencing. You can do that via Zoom, okay?
Yes, ma'am.
And I think you have a blue sheet with the contact information for Zoom there.
To confirm, he does, Judge. He does have the blue sheet that contains all of the Zoom information for this court.
Okay, you need to make sure you have video capabilities when you log in for Zoom, okay? Please say yes.
Yes, ma'am.
Has to be in a quiet space, not like in the bus station or anything like that, okay? Do you have any questions?
No, ma'am.
Any additional matters for the record?
I have nothing further, Judge. Thank you.
Thank you, you're all set.
I'm just running. Yeah, so it's 1,000. On those, this one obviously shows 10% now. But she's not. That's all. I have my best sheet somewhere. And it went all down the floor. What's that?
It just gets you to find what happened.
Are you ready with Mr. PV?
Papers lying around.
Could I just have a quick minute to speak? with the
Absolutely.
judge?
Skip breakfast. Skip breakfast. And get out.
On the record in the matter, the people of the state of Michigan versus Andreas PV, file number 22-01090. Council appearance.
Brian Ring on behalf of the people. Thank you, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Mr. PV, the gentleman standing to my right.
Okay, it's a date that was set for a preliminary examination. My understanding is that the parties want to unconditionally waive their examination. Is that correct?
That is, Your Honor. That's also correct from the defense.
Is there an offer?
Yes, there is an offer to be placed on the record. Your Honor, the offer was used to an account of home invasion second. We would dismiss the home invasion first.
And Judge, just for the record, that is the offer that's been communicated to me. We are not taking any position on that. We anticipate that negotiations will continue at the circuit court level. But certainly Mr. Ring is absolutely correct. That's the offer.
Okay, and Mr. PV, you understand that you have the right to have a preliminary examination on this file here in the district court.
Yes,
You understand that the purpose of the preliminary examination is to have the prosecution establish their burden of probable cause. They have to put on that there's sufficient evidence to establish that there's probable cause or the crime was committed and probable cause to charge you with the crime. You understand that?
Yes.
Do you want to waive that hearing today? Any promises made to you to get you to want to waive your hearing? Anybody threatening you to get you to want to waive your hearing? You're waiving this hearing freely and voluntarily? Okay, and you understand that the waiver is unconditional, so that means you can't come back later and decide you made a mistake and you want to have your exam. You understand that? Okay. Matter will be bound over for a bind over date of November 9th. That's not a date that you have to appear in court. That's the date that the circuit court gets the file from this court, okay?
Yes.
Your next court date will be a pretrial. You and your attorney will be made aware of that date, okay? On the set at $100,000 cash surety.
Judge, could we address that today again?
Again,
Thank you, Your Honor. I would ask the court consider a significant reduction in that matter. My client, obviously, my client's been in custody for some time. I will point out that this incident that was just waived is alleged to have occurred almost a year ago in January of this year. My client does have a stable address at which he can reside. He has supportive family. He has family members here that are in the courtroom today. They are obviously concerned about him. My client is dealing with some mental health issues. I don't want to put the details of those on the record, but he's dealing with some mental health issues. He also has a job lined up for him if and when he is released to be working at Bridgewater. I don't believe that he's a flight risk. I don't believe that he is a danger to the community. I understand that the allegation in this matter is a serious offense. There's no getting around that, Judge. I would suggest to the court that the safety of the public could be secured through other methods such as a GPS tether. What I would really like to see, if at all possible, is to have my client released so that he can start working on addressing some of the mental health issues that he's struggling with. I am very hopeful that his dealing with those can help him make significant improvements in his behavior and his outlook, and also kind of get him into a better place. I also know that his grandmother, who's present in the court today, has some serious health issues. My client resides with her at the address, which I believe the court has on file on Western Avenue. He helps take care of her when he's not working. I would ask the court to take into account all of those matters in addressing the client.
I think I asked this before. Was he either on probation, parole, or had a pending matter when the allegations took place?
He did, Judge, not in this court or not in this county, I should say. He had a I believe he was on misdemeanor probation, in Eaton County at the time of the alleged offense in January of 2020.
I can tell you now the reason why bond was set the way it was is because the original charge, but the position taken by the prosecution at the time of arraignment.
I understand, Judge. I'm simply making my argument.
Thank you, Your Honor. We just maintain, Your Honor, that the allegations in this are very serious, Your Honor, and the victims being two 12-year-olds at the time of this allegation, Your Honor, we would ask that bond remain in place.
I think I indicated this at the last hearing. The charge is home invasion first degree. That's a felony with a maximum penalty of 20 years and or 5,000 in fines, and a consecutive sentence may be imposed or any other conviction rising out the other the same transaction. But there's a number of factors, and I recognize the age of the case is from January. There's a number of factors that was taken into consideration when this bond was set. And those factors not only include the fact that the defendant was already under court supervision at the time in which the allegations took place, but that the defendant has a history of violent behavior directed toward the alleged victims, and that he has a history of threatening and harassing behavior toward victims and witnesses. There's also allegation of escalation of violence and threats to kill, allegations of threats to kill a victim or family. And so these things were what was taken into consideration, as well as whatever the arraigning judge was able to see on his prior criminal history, which I don't have before me. I don't have those factors. I just have a request, which I'm going to deny, like I denied last week, because I believe there is a threat to the public safety. And I think that we need to get more measures or some more assurance that measures are going to be taken in place if he is released to address the mental health issues. Not, we just want to release him so he can address it. Well, how is he going to address it?
I understand, Judge. I understand the court's position. I guess we can address that again.
He can obviously make a motion so that the bind over date can be an arraignment date, and then
Right.
we can address bond at that time.
I don't think we need to do that now, Judge. What I would prefer to do is to have a circuit court judge set, and then we can file a written motion, get pretrial services involved and that kind of thing. So certainly we'll take that up at the circuit. I understand the court's position. We'll take it up again. At the circuit court.
Oh, very good. Any additional matters for the record?
Nothing from the people, Your Honor. I have nothing further to say.
Thank you. You're all set for today.
I need to sign the waiver. Right. Yeah. Yeah, you know what? I think that was the old style form still. It didn't have
It didn't have me on there?
I didn't think so, but maybe it did.
It doesn't.
You can just sign it underneath my name or something.
Yeah, I don't know what that's all about. Why does it look like that?
I mean, theoretically, the prosecutor has to consent to the waiver too, so it makes sense that the prosecutor's signature line down there.
Okay. Are you ready on your matter, Mrs. Neal?
Yes, I am. Thank you.
Okay. Thank you.
Okay.
Oh. No, if I may approach.
Yes. Okay, we're on the record in the matter of the people of the state of Michigan versus Bruce Herman ED file number 22-01596 FY, council appearance.
Thank you, Your Honor. Randall Berman, on behalf of the-
Good morning, Your Honor. Adriana Neal on behalf of Bruce Eddy, who is present and standing to my right.
How are you, Mr. Eddy?
Good, Your Honor. How are you doing?
I'm doing pretty good. Today was the date that was set for preliminary examination. I have a plea sheet here. It says that people are offering for you to plead guilty to an added count 2 of larceny 200 to 1,000 under MCL 750.3564A. It's a misdemeanor 1 year and or $2,000 is the fine or 3 times the value of the stolen property, and other people are moving to dismiss the original count 1. Is that what you understand your offer to be, sir?
Yes, Your Honor.
You want to accept that?
Yes, I do.
Says here, there's a killable of no upfront jail and any restitution to be determined if any. That's also accurate.
Yes, it is, Your
I have an advice of rights, the information sheet with today's date on it. That's your signature?
Yes, it is, Your Honor.
You read these documents, sir?
Yes, I have.
Did you understand the rights listed here?
Yes, I do.
Do you have any questions about these rights?
No, ma'am.
You understand that you have the right to proceed to trial in this matter?
Mhm.
Is that a yes?
Yes, I'm sorry.
Oh, you're fine. And you understand that at the time of trial, you have the right to be represented by counsel. You have the right to be presumed innocent until proven guilty. You have the right to see, hear, or question any other witnesses the prosecution intends to call. You have the right to call your own witnesses or present evidence that you believe would further defense to the charge. And then you have the right to have each element of the charge being brought against you proven beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You wish to waive all of those rights today?
Yes.
Is anybody threatening you to get you to waive those rights?
No.
She's tough, right?
She's
But she's not threatening you.
She's tough.
I know she's not threatening you because you made me adjourn this so that you can hire her. So you must,
I appreciate your patience, trust me.
no worries. So she's not threatening you, correct? And no one else is threatening you.
No,
And no one's making any promises to you to get you to waive your right to plead guilty.
no.
And you're pleading guilty because you believe you are guilty. Are you pleading guilty because you believe you are guilty?
Yes.
You're currently on probation or parole.
No, ma'am.
Okay. You understand that a guilty plea could result in a conviction that you might need to report to your employer or to a future employer?
Yes.
You understand that a guilty plea could have an impact on any immigration status you may be seeking, like if you wanted to move to Canada?
I understand.
Okay. And there's a killable agreement. That's an agreement between you and the prosecutor. I'm not a party to that. So if at the time of sentencing, I decide to deviate from that, I would give you an opportunity to withdraw your plea, okay?
Yes, ma'am.
Your Honor, if I may note for the record, it's come to my attention that Mr. Berman, perhaps in his past life as a defense attorney, represented Mr. Eddy.
Oh.
And Mr. Eddy did acknowledge that. He has also advised me that he doesn't have any issue in terms of proceeding with Mr. Berman as a prosecutor in this case for the plea today.
And I didn't realize it until I saw him put the name together, because it's been a long time, but I felt like it's possible I had represented him in the past. And what I can say, Your Honor, is I didn't really handle the file. I didn't charge it. Mr. Ring has been dealing with it, and he came to me and said, can we do a misdemeanor on this? And I did approve it. So I've taken nothing that I know about Mr. Eddy, because I didn't realize it until just now, into account in okaying that plea offer. It's something Mr. Ring pretty much did on his own after we discussed the case, and it has no influence in my eyes, and I don't feel like it prejudiced my office or the people in any way. So just want to put that on the record, because I'm sitting here, the name started to ring a bell when I saw the face, and I'm like, this happens once in a while. My
Yeah.
memory stinks, and I can't always remember for private practice. Certainly, it's going to be 9 years in April, so it's been a long time since I was in private practice. So sorry about that.
Oh, no worries. It happens, right? So you or your client believe that he's being prejudiced at all in any way, correct?
No, Your Honor. Thank you.
Okay, so there's no reason why We would not need to be able to proceed at this time. I appreciate you disclosing that on the record.
Right, I just want to be sure that Ms. Neal had an opportunity to speak to her client, make sure that he realizes, if he recognized me, that I'm not using anything that he thinks I know about him with this, because I didn't remember. till now.
Did you recognize him?
Yeah, I thought he looked familiar when we walked on the hallway and I'm like, you know, yeah,
Couldn't place where you remember him from?
it's been a while.
Yeah, got it.
It's
Okay.
been a
It happens.
Yeah.
Okay, sounds good. So that will be noted on the record, but I do agree that there's likely no prejudice to the defendant at this time. So as to the added count 2 of larceny, 200 to 1,000, you plead guilty, not guilty, or stand mute?
Guilty.
Okay, get on a factual basis.
Yeah, thank you, Your Honor. Mr. Eddie, on or about February 1st of 2021, were you at or near 1103 Ballard Street?
Yes,
And that's located in the city of Lansing, Eaton County, Michigan.
yes, it is.
And what is located at that location?
It's a shot.
And at that time, did you have someone else's property, specifically Wallace Fat Bites property?
Yes,
And the property essentially was taken without consent, and that you received the bites but hadn't made payments when you received the invoice. Is that correct?
yes,
And so there obviously was movement of the property because Wallace shipped the bites to your shop.
yes, it is.
And is it also true that the fair market value at the time that you received the bites for the purposes of the plea was $200 or more, but less than $1,000?
Yes,
And you in fact didn't make full payment for the bikes, but the Michigan State Police recovered the bikes from your property and took them off the property.
yes. I'm sorry. Yes,
Thank you. Your Honor, I believe that is a sufficient factual basis for the plea of larceny 200,000.
Factual basis on the front.
It didn't cover, but I didn't necessarily hear that happened in the city of Lansing County, maybe.
Yes.
Further question, John, thank you.
What is that the factual basis? I'll accept this plea. Trying to prove you may prove voluntarily and intelligently. Do you know if there was restitution?
I believe there was an outstanding amount. It's my understanding some of it may have been already paid, so we need to get all that confirmed and ask that the probation assist in that regard, or we'll get them what information we have.
Sounds good. What's that for sentencing? Sentencing for Friday, December 16th at 1 p.m. work for you?
Yes, Your Honor.
Okay, we'll set it for that date and time. When you leave here, sir, you should go by the probation department so you can meet with them and they will get you all set up for your pre-sentence interview, okay?
yes.
Okay. Do you have any questions? And that sentencing date can be via Zoom. Any questions?
No, ma'am.
Okay. Any additional matters for the record?
Not on behalf of the people, Your Honor.
Not on behalf of the defense, Your Honor. Thank you.
Thank you. We'll see you in December.
Thank you. Have a good day.
You too.
Thank you. Thank you, Your Honor.
And I got dismissed and done.
No.
Yo,
What'd you stamp on the notice?
thanks, yeah, I just gotta do that thing for Mitchell's ready to go. Garland's gonna get- I know, I already talked to him.
I'm just thinking.
What a watch.
Already signed it. He's here downstairs.
Okay, who's next? Are any of these actually running exams?
Mr. Cleveland will be running. My two are gonna be pleased, so Judge, I'm just finalizing. paperwork.
I have one now that's in custody.
Is that Venegas?
Yes, ma'am.
Okay, well. Well, I don't see Mr. Oh, Daniel, guess we can go to get two people at the same time.
Just do the dismissal, you waive the negative appearance and then just don't.
Yeah, I don't have to go on the record unless you can advise him of what not without prejudice means. That's assuming it's being dismissed without prejudice.
Yes, I can give that, Your Honor, if you want me to run down. before
Yeah.
While you're doing the other matter.
That works. Because Darlene and Mitchell are here in person, right?
Right, yeah. I can just do that while you're doing that.
Did they get their fingerprints done? Okay, then I guess. I don't have a file, so I'm assuming he already took it. He already took. What's yours next? I was at my file. I already signed it, that's why.
Yeah, no.
Yeah,
get some.
So you can tell us the guy next to him.
Just happened to walk in the hallway.
Well, yeah, I'm glad you come
So
here.
that officer send us
Better not come in.
here. I don't
Thank
know.
you,
I
ma'am.
didn't see it.
No problem, have a good one.
You can just connect.
I'll be right back when I try to confirm.
We'll run down the judge.
Yeah. I'm just kind of holding my breath.
Hey, man, can I get one more copy? I think you tell me something in this case or was it? No, it was actually. Yeah, sorry, yeah, it's tomorrow. Yeah.
Okay, gotcha.
Does he have other stuff pending?
What's that?
He has other stuff pending?
Yeah, he's got a case in front of Chaney. Just a high candy. Same thing said. Either one or two things. I'm not sure which one.
Right.
I have a good idea, but.
Coin toss, right?
No, not really a coin toss.
There's science behind it, Mr. Ray.
The problem is if I can do my job well enough and advocate for something else.
No
maybe
pressure.
Give me what I want. Not optimistic.
Let's see here. I need my protein.
some reason I didn't see it.
No worries, we're good.
Trying to trick you.
Move it along.
Sure.
Gotta be my nails done. I broke like four of them. Okay, this is Mr. Dan Darling.
It's correct, Judge.
Okay, we're on the record in the matter of the people of the state of Michigan versus Dan Lee Darling, file number 22-02645 FY. Council appearance.
Brian Ring on behalf of the people. Thank you, Your Honor. Robert Plummer, the Public Defender's Office, on behalf of Mr. Dan Darling, the gentleman who stands to my right.
How are you, Mr. Darling?
Good, how are you?
I'm doing pretty good. Somebody tell you you have to wear a mask?
I just choose to.
Oh, okay, well, if you're gonna wear it down below your nose, how does that help you?
No.
Did you go get your fingerprints taken care of?
No, I have not done that.
I didn't realize that was an issue, Judge. We can have that taken care of today.
Okay. Okay, today was the date that was set for preliminary examination. I have a plea sheet here. It says that the people are offering for you to plead guilty to an added count 3 of larceny 200 to 1,000 under MCL 750.3564A. That's a misdemeanor. Maximum penalty is 1 year and or $2,000 in fines or 3 times the amount. And they're going to dismiss the remaining counts 1 and 2. There's a killable agreement, which is a sentencing agreement between you and the prosecution, that you will be sentenced to no upfront jail. Is that a complete and accurate understanding of the plea offer?
Yes, Your Honor, added the restitution of both counts, Your Honor.
Do we know the restitution amount at this
We
time?
do not at this time, Your Honor.
Mr. Palmer.
That is an accurate statement of the plea offer, Your Honor, and like Mr. Ring said, we anticipate that there will be a restitution issue. We will try to determine, we're going to ask that a restitution hearing be set for the same day as sentencing. It's a little bit strange of a case in terms of trying to figure out the exact restitution amounts. Certainly our hope and desire is that we can get that worked out ahead of time. And it may very well be that by the time we come back for sentencing that there's a stipulated order to that or stipulated agreement to the amount, but we'll ask that it be separate hearing at this time.
Okay, sounds good. And Mr. Darling, you heard the offer that I read.
Yes, Your Honor.
You want to accept that offer?
Yes, Your Honor.
You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do, Your Honor.
Thank you. This advice of rights
Yeah.
plea information sheet has a signature on it. Whose signature is that?
Mine.
Did you read this?
Yes.
You understand the rights listed here?
Yes, ma'am.
Do you have any questions about these rights?
No, ma'am.
You understand that you have the right to proceed to trial in this matter?
Yes, ma'am.
You understand that in order to plead guilty to the added count 3, you're gonna have to give up that trial right?
Yes, ma'am.
You're also gonna have to give up your right to be presumed innocent until proven guilty. You understand that?
Yes.
You're also giving up your right to see, hear, or question any witnesses the prosecution intends to call. You're
Yes,
giving up your right to call your own witnesses or present evidence that you believe would further a defense to the charge. You're giving up the right to remain silent and not have silence be used against you. And you're giving up the right to have the prosecution prove each element of the charge being brought against you beyond a reasonable doubt. You understand that?
Yes, Your Honor.
Anybody threatening you to give those rights up?
No, Your Honor.
Anybody make any promises to you if you give up your right?
No, Your Honor.
Are you pleading guilty today because you believe you're guilty?
Yes, Your Honor.
Are you currently on probation or parole?
No, Your Honor.
You understand that a guilty plea will result or could result in a conviction that you may need to report to either your current employer or to a future employer?
Yes, Your Honor.
You understand that a guilty plea could also result in a conviction that may have impact on any immigration status you may be seeking. Okay, as to the added counts 3 of larceny 200 to 1,000, how are you pleading?
Guilty, Your Honor.
Do you have a factual basis?
Certainly. All right, Mr. Darling, I'm gonna take you back to August 19th of 2021. On that date, were you at or near 725 East Kavanaugh?
Yes.
And that, as far as you know, that is in the city of Lansing. That location is within the city of Lansing, Ingham County, state of Michigan.
Yes.
And at that time, on that date and at that location, did you, well, let me back up here. Mr. Darling, you are a contractor or subcontractor for construction work, is that right? Subcontractor. And at that time and on that location, you accepted some money for the performance of a job, is that right?
Correct.
And so you received the money, but did not ultimately go back and perform the actual work, is that right?
I received the money, but didn't complete. the work.
Did not complete the work, all right. And so you would agree with me that you ultimately became, you received money for work, at least some of that money for work you never performed, correct? I believe that satisfies the factual basis for that, Your Honor.
Any questions, Mr. Ring?
No, thank you, Your Honor.
Or dissatisfied with the factual basis, I'll accept your plea. How your plea be made freely, voluntarily, and intelligently. This matter will be set for sentencing. Sentencing is going to be December 16th, 2022 at 1 p.m.
And just to confirm, Judge, the restitution hearing will be set for the same day.
That's correct.
Thank you, sir.
Shuffle that in as a restitution hearing as well. Thank you. Prior to sentencing, sir, you need to meet with probation so they can provide the court with a pre-sentence report and recommendation. When you leave here today, you need to do two things. A, you need to go get the fingerprint situation taken care of. And you also need to go and see the probation department. They're on the 5th floor, okay? And then they'll get you set up for your pre-sentence interview. Do you have any questions at this time?
No, Your Honor.
Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing from the defense, Judge.
Okay, you're all set, sir. Thank you.
All right,
We want to do Mitchell next.
Yes, please, and then we need Cleveland brought up.
Brian's gonna be secretary, he's gonna be fighting his sister on this
How is effective? Huh?
Nope.
I mean, this is,
This is Mr. Mitchell, Judge.
oh, okay, very good. We're on the record in the matter of the people of the state of Michigan versus Robert Edward Mitchell. File number is 22-02635 FY, council appearance.
Thank you, Your Honor. Randall Berman on behalf of the people. And thank you, Your Honor, Robert Palmer on behalf of Mr. Mitchell, the gentleman who stands to my right.
Okay, how are you, Mr. Mitchell?
good, how are you?
Okay, thank you. Today is the date that was set for a preliminary examination. I have a plea sheet here. It states that the people are offering for you to plead guilty to an added count 2 of use of methamphetamine under MCL 333.744042A-A. That's a misdemeanor. Punishable with a maximum penalty of 1 year and or $2,000, and they are consenting to 7411 if you are eligible. Do you recall that being your offer?
Yes, yes.
Yes, Your Honor.
Oh, okay. Okay, sounds good. And then you want to accept that offer?
Yes.
Your Honor,
Yes.
if I may, if for some reason the defense not eligible for 7411, I'd like to add to the plea agreement that there be no upfront jail for time sentence. Suing for people versus Killebrew.
Okay, also a killable of no upfront jail.
Thank you. Yes, Your Honor.
Okay, and that's also part of your offer, sir,
Yes.
and you're willing to accept that?
Yes, yes, yes.
Can you raise your right hand? You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Okay, you can put your hand down. Okay, I do have here plea advice and rights and plea information sheet with date of today and name and addresses, but is that your signature?
Yes, Your Honor, it is.
Okay, did you read this document, sir?
What's that?
Did you read this?
Yes,
You understand the rights that are here?
yes, Your Honor.
Do you have any questions about any of these rights?
No, Your Honor.
Okay, you understand that you have the right to proceed to trial in this matter?
Yes, Your Honor.
And are you willing to give up that right today in order to accept the offer?
Yes, Your Honor.
You understand that you'll also be given up the following rights. That is the right to be presumed innocent until proven guilty. You're gonna give up the right to remain silent at trial and not have silence be used against you. You're gonna give up the right to see, hear, or question any of the witnesses the prosecution intends to call. You're gonna give up the right to call your own witnesses or present evidence at trial that you believe would further a defense. And you're gonna give up the right to have the prosecution meet their burden of proof at trial, which is to prove each element of the charge being brought against you beyond a reasonable doubt. You understand that?
Yes, Your Honor.
And you're willing to give those up today?
Yes, Your Honor.
Anybody threatening you to get you to give those up?
No.
Has any promises been made to you if you give up your rights today?
No, Your Honor.
Are you currently on probation or parole?
No.
You understand that a guilty plea can result in a conviction that you may need to report to your future job or to a current job.
Yes, Your Honor.
You also understand that conviction could also impact any immigration status you may be seeking.
Yes, Your Honor.
Okay, and the prosecution has added a Killebrew agreement. That's an agreement that I'm not a party to. You understand that?
Yes.
I'm not agreeing that I'm not gonna put you in jail. You understand that?
Yes, Your Honor.
But if I decide at the time of sentencing that I will sentence you to jail time, I would give you the opportunity to withdraw your plea, okay?
Yes, Your Honor.
Okay. As to the added count 2 of use of methamphetamine, how do you plead?
Guilty, Your Honor.
On a factual basis.
Certainly, Judge. All right, Mr. Mitchell, I'm going to take you back to January 25th of this year, 2022. On that date, were you at or near the intersection of Pennsylvania Avenue and I think it's pronounced Held Place? All right, and that location is within the city of Lansing in Ingham County in the state of Michigan. And at that time, did you have a substance in your possession that was methamphetamine? And you knew it was methamphetamine? And you did not have any valid prescription or some legal basis for possessing that methamphetamine, is that correct? That's correct. I believe that satisfies the factual basis.
Any questions from the prosecution?
No, Your Honor, thank you.
The court is also satisfied with the factual basis. I'll accept your plea and find your plea to be made freely, voluntarily, and intelligently. I have a whole lot of sentences at 1 p.m. on
Yes, ma'am.
December 16th.
I'm knocking the whole docket down. Apparently.
And so this will be set for sentencing December 16th at 1 p.m. I also have an indication here that you have not taken care of your fingerprint. So you need to do that today, okay?
Yes, Your Honor.
You also need to, after getting your fingerprints, you need to go down to the 5th floor. Well, you'll come up to the 5th floor after that, so that you can meet with probation. They'll get you set up for a pre-sentence interview, and you're gonna have to undergo a substance abuse assessment, okay?
Yes, Your Honor.
Sarah, bro. Okay, very good. Okay, do you have any questions today?
No, Your Honor.
Okay, any additional matters for the record?
Now, on behalf of the people, Your Honor, thank you.
Not from the defense, Judge, thank you.
You're all set.
Thanks.
Yes, indeed.
Okay.
Oh, it's okay.
I'll take another one right now.
Yep. We can address the dismissal on the record.
Who's dismissal?
We already did that. We already took
I
care
think
of
he
it?
went down and spoke to him, yeah.
Okay, so we're good. I think I did the nollie and,
Yep, I signed it.
okay, thank you, Your Honor.
Thanks for having me.
To see you later.
Done. Cleared that docket out. I like that already.
Well,
Okay.
About my samples. You get to the charger one before I leave?
I have one in my bag.
I got one as well.
All right, guys.
Thanks, Randy.
Thanks, Randy. It's not. So you're gonna use it, they can see it, so. If they want to run. So I don't think,
Yeah, can you send her?
Yeah, I think I had
Also the same that usually sometimes it is. Yep. Gonna get a mark. Yes.
And because it's reaction.
Seems like you're not the same thing.
Makes sense. Okay, thanks, boss.
Next one.
And I can get if you make calls.
I told you what happened.
You can get usually I.
No.
I didn't want to do it either. I want to do it myself. Just not gonna go.
I thought my guy might swing on me this morning.
Yeah.
He's getting a little pissed.
I did it.
I saw you guys all stand up. I appreciate that, by the way. I'll just say that. I saw you guys all right there. That's also part of the reason I walked them down to that platform down there. Is because I was like, well, the boys are around. I'm standing down here, the boys are around.
Oh, I know.
Yeah.
Okay. Rip on the
Wow, we cleared that out. I know.
I also need this.
Four of them up, four of them down. We didn't have to run anything.
I had 8 today that I didn't know. I only knew
That
one.
was
I only
even
knew.
together.
And which ones you admitted? Can I see them?
Same report,
Same report.
text photo, potentially the like a photo, and then the 10-12 deal.
Okay.
What?
So where?
Do you want me to do
I mean, I've
it?
had little.
No, I can do it if you want.
I can, I just
Oh,
didn't know
the
you said you
arena.
needed.
I thought you meant like a pizza shop. I was like,
Yeah, you guys are
I
fine with me
had
writing it down.
Yeah,
I'm
that's
fine.
fine.
No,
I just know
I've not
sometimes
been
the
there.
court's
My
like, no,
daughter
we
was
have
for
to.
Billy
do
Idol.
it. If you do it, it's not okay.
Yeah, no.
I'm like, I'm pretty sure it's okay.
Were you going down there for a hockey game?
No, a Pistons game, a buddy of mine's cousins coming to Israel. I was like, hey.
Carry on.
Yeah, I love them. Thank you so much. Yeah, so we said, do you want to go this? Yeah, so there. So she would be down.
Yeah. I've not been down there.
I'm not a big Pistons.
Wow, that's really terrible.
What do
The
you mean?
arena looks really sweet.
It's good. That's how I know it.
It's phonetically, that's there.
Yeah, I've not been down there.
No, that's all.
I hear it sometimes. But I've not been.
You were in military intelligence.
Bro, military intelligence is an oxymoron.
I'm seeing that.
That's your text message.
Yep. And then, just marking this one, it's 10-12 call. Yeah, code word, move them.
Oh, yeah, okay. I like that code.
I do too. I think it's a great idea.
Yeah.
I think it saved your life.
And
She feels it saved your life.
Yeah.
And frankly, I agree. Because he told her, I'm going to kill you.
Yeah.
And then the reason he did is because the cops were knocking on the door.
You know.
Look,
That's usually. That's
I
usually.
take the man at his word. Whenever someone threatens somebody, I take them at their word, and I trust them.
I like to dare them to do it.
Fair enough.
You gotta see. You gotta little. It's like right here. Can't see it. I don't know if it's one against it or.
Shit. Oh, well, let me see. Why I gotta burn it?
No, let's take it back. Can you see it? Oh, yeah.
What's your guy charged with? Are you about to run?
CSC first. Oh, yeah.
Unlawful
CSC
imprisonment.
unlawful imprisonment.
So there will then be an added DB third, interfering with the crime report, interfering with electronic communications, and 10-year witness interference.
That is all right.
Oh,
There, depending on how it goes, there might be a second CSC first, because I don't know how it's gonna shake out. in the testimony.
No.
Adam's training. Listen to those jail calls, and so you can deal with that too.
He says, and I quote, if you don't
testify, I won't harass you anymore.
And my buddy Clarence here will make sure that I don't.
And Clarence, who's running the third way, said, yeah, I'll make sure he doesn't bother you anymore. You just don't testify.
That's not a good fact for you, Michael.
He was
No,
like,
I'm well aware
he
of
was
that.
like, he was like, swear on your dead grandmother, and Clarence like, I don't think she needs to do that. People
And literally, I just don't know if it's bribery or intimidation. I won't hurt you anymore if you do this. I don't know if that, I think it's more bribery. I don't give anything of value, which is no further meetings.
I don't know, I think I would go, I'm arguing against it, but.
Luckily, it's all under the same statute, so.
Yeah. I might have an intimidation.
That's why I love the bribery statute, because so many things fall under something of value.
I don't know if it's all getting swallowed into the CSC one anyway, so we can lie.
Yeah.
I'm trying to remember which case it was, but he promised her a baby.
I think you were
If she
telling
doesn't
me
come to court and gets dismissed, and he gets out, he's gonna give her a baby. She just squealed in response. And at the sentencing, or at the plea, we're talking about, and he just wasn't getting the facts out, like that he gave her something of value for the bribery. So that's what led to it. I'm like, sir, did you promise her a baby? Yeah. Did this seem to be a positive thing for her? Yeah, it did. Thank you. Your Honor, well, I do not believe having a child with this individual would benefit my life. She clearly did.
I think that's a little bit of a stretch to private.
Something of value. I'm sorry, kids are a lot of money.
No, they're a drain.
I don't know if I
They're
said
dead.
a lot of money. What's the price of a child?
Look how much it takes to adopt somebody.
Yeah,
That's true.
that doesn't mean it's got value in the
But
open
no,
market.
we found case law that like love and affection is something of value.
Wow. We should just get on this one.
Ooh, that was a long morning.
I was ready to finish up an exam. and use the emergency room. I did open heart surgery.
Yeah.
I see back
I got an appointment for my consult for Sergio.
I see back in the
Monday.
You want to stick around for the next 3 hours, Rob?
This isn't true.
I was about
My
to
daughter
say
just
3
says,
hours.
"You need to put money on my lunch.
Steve, a lot of that's gonna be on you.
My daughter put some of her own money on her lunch account the other day, so she could buy muffins. She could
Yeah,
buy a
that's the
muffin.
problem. I'm like, you don't buy the regular lunch.
No,
you buy
the
all
3 hour
the
one I
expensive-
had
My son
was
only
one where there
buys-
was video of the assault with
They both
Judge
take a
Ward
cold lunch.
with two co-defendants,
But my
two
son
different
thought I
attorneys.
had
And
my
literally they were
$7
stopping
from
every
my dad. I
half
was like,
second
okay,
and pausing
you
and being
take
like,
your own money,
now tell
whatever
me
you
about
want.
this.
Yeah.
And we weren't
no.
watching
I'm
the
not
full
gonna give you
video.
an account so you
Like
can
we
buy
didn't even
this
play
stuff.
full video.
Like,
He
peanut
just
butter,
kept stopping every
granola
half
bar,
second.
Reese's
I
Cups,
just-
Oreo
Yeah,
chips.
she
So
buys-
angry.
I did that on Bosco sticks,
Yeah.
like roasted sticks.
We just watch it. Oh yeah, sure.
Asked
You're
my
like,
kid
oh,
the
keep
other day,
pausing
"What do you
it.
have for lunch?"
I was gonna say, we can-
And then keep
For
doing
an
it.
assault,
Have
we
lunch
can watch
at
a
Bosco
video.
sticks.
See.
And it was
Bosco
literally
sticks.
3 hours.
Every day they ate Bosco.
And it was the most
I know.
painstakingly
9 and 12.
questioning and bad questioning I've ever heard. Like it
Oh,
accomplished
geez.
Yeah, that's
nothing.
my 12-year-old.
And the victim was just getting
Then my son will
obstinate.
try to
She
sneak
was
his
so
debit
frustrated
card,
because by the end of it,
his own account.
Dang.
He'll try to sneak
because she's
his
on
food, buy
video
shit.
being beaten with baseball bats down on the ground.
Oh, I think I know which one you're talking about.
Yeah.
That one was
Just-
super
yeah.
long.
Yeah.
I remember
Forever.
that.
That day,
Well, it's a-
and I had other
we
exams.
got
that
in their
were
own
going.
accounts to
That day,
try to
I
help
started
keep track,
to
like, to teach them
at
how to keep track
8:30,
and
and I
manage their
ended
money,
at
but
4:30
it's not working.
with no breaks.
Oh, no.
My son will go spend
I
like
do
20
remember
bucks, and won't come back and put it in his ledger that he spent 20 bucks.
Yeah.
And then they're like, Dad, how much money do I have? And I've got to pull it up on the thing.
I opened it up because when I was a little baby, I got a whole bunch of these savings bonds.
Ooh, I just
do.
cashed out.
Yeah.
I just cashed out $1,400-$1,600 worth of savings bonds. It was great. Savings
Must be
bonds.
nice to have been older in that time period to be able to get savings
Yeah.
bonds as a child.
You can still get them. They're just digital now.
Yeah.
Because my kids have
Yeah,
them,
Yeah,
but
so
they're
yeah,
digital.
everyone gave those when I was born.
But they don't actually have certificates anymore. They just do them
Yeah.
digitally. But yeah, my dad was like, I was talking to my dad. He's like, oh, I got a bunch of savings bonds here, and they're like half of them are matured.
Yeah.
And the face value was only like $800, and they doubled. I had $1,600 out of the $800 worth of savings bonds. And then I blew it on shit that I don't need.
Yeah.
I have money in the bank. That's what I have.
Yeah, we'll try.
How's it going, Rob?
See you guys.
I have money in the bank too.
What branch of the service are you in, Brian?
All right.
You, just an officer or a ranger?
No, I was enlisted. I was military intelligence.
Yeah. What's his, I can't think of the other guy's name, the older guy.
Bill.
Bill, so was he military?
Yep, yeah.
Okay, I was gonna say.
Yeah, Bill and I
Yeah,
talked about
I thought,
it.
I thought he was army, just by his.
Bill and I talked about it all the time. I'm really sad to see him go.
He's leaving.
Yeah, but tomorrow was the last day.
Where's he going?
He's got some family business to take care of in Carolina.
Oh, this Bill. I
Yeah,
thought you were
like
talking about
Bill.
Bill Carino from our office.
Oh,
I'm
no.
like, Bill is in the military?
No, that, Bill at the.
Yeah, I like Bill. And you're the one that's been here for a while, because Carly left.
It'll be 4 years December.
Yeah, and what's his name left? Football.
Are they waiting to bring him up or?
Yeah, they're waiting.
Yeah, they want to get him. A year and a half, and then I'm done.
Wow. Were you cop before?
I was a supervisor at the animal control,
Okay.
building supervisor.
Oh, I thought I seen that. Yeah, you have trials coming up, Anna, in Dragon Check?
I was supposed to. Umar Taylor fired Toby White after 2 years,
Really?
3 days before trial.
Dragon Check let him out?
Yeah,
That bad, huh?
Toby got him the plea deal he wanted. He's
Yeah.
like, give me under 3 years and I'll take it. And Toby got that. And literally, he was with Toby for 4 hours night before the hearing. The final pre-trial, and was like, yep, I'm taking it. It's good. Went through all the evidence, like, yeah, I'm gonna do it. And then he walks in that courtroom day and says, oh, I don't want you anymore. Yeah.
Not too bad. Once you talk to Steve. Well, right now, we got one on Wednesday. Yeah.
They play TCU.
TCU is on a roll this year.
Yeah.
So, those rest of the too as well. The best thing which is. So you want to know something. Just want to wait up on the. No.
Yeah, yeah. Yeah.
No.
I had one that flew in my pocket. I just don't know.
They usually keep it doing my bag. I'm all out.
Which honestly is better for some.
That's what I'm saying, but I found
There is for it. Which were hearing the new, there is first.
That's pretty good.
It was different.
Different, good way, or
It wasn't the traditional.
crust different?
Crust is good. But crust is the same as the regular pizza. But usually it's like a big side has beans and cheese and lettuce.
Some beans or nothing.
It was.
It's very light. It's light on the. I put this way, it was fast.
Type of pieces that you generally get. Or I have the ground beans, the ground beef over the top, cheese over the top of that.
Yeah, it's nice. The beans. That's breakfast food, like, $3 same thing, beans and everything. Friday and on top.
We went to breakfast and at the nickel. The word nickel.
They got breakfast pizza there too, right? But another place. One of those places.
But the Nichols refused to raise its prices. So it's gonna use the same. So build your own omelet. And their sausage is all spicy. So I like their sausage. Sausage, onion, Swiss cheese, home fries, homemade toast. $3.
$8.
Yeah. Wood nickel. Yeah, more than you can eat. So both of us for breakfast was $16.50.
Did you ever go to the depot? Yeah. Wow, yeah. Same thing.
That's what she had.
Sorry. So I get.
Look, no offense, once they come out, if there's a round.
So,
Oh, if you just follow them.
So take the plate, first
Again,
whole plate.
anyone.
All the fries on top. Then
I don't know
on
that.
top of that, scrambled eggs. On the top of that,
Like-
bacon, sausage, and then sausage gravy. over the whole thing.
Yeah, that's what we have.
Plate weighed like 7 pounds.
There's good nap that word.
That's like plate was a buffet. It's like plate was one.
It would be, it would be.
Yeah, I got
So
it.
you
Under
see
that
the
time,
first
even
French
more
toast.
It's a lot of carbs.
Yeah, okay. You don't get 260 without eating carbs here. Yeah, get my bear wrestling right.
Did you ever show Edmund? He actually wrestled with
Shoulders. They wrestled a bit.
That's nice.
Yeah.
She told me.
I never wrote it down. Well, it depends if it's my note. My sense is that I'm going to keep that. Really doesn't make sense.
And then the spot out of the nail starts part. You can't. You can't be on top of a bear. It's got 4 legs. Just kick it. Bad thing. You just feel like a bear for a week.
Yes.
Yeah.
So what's next up?
Yeah.
Well, depending on what happens.
Is there open?
You know what's gonna happen.
I know, that's why.
Yes. I remember hearing about that.
Yeah.
What time can I look?
Yeah.
Very hospitable for all this.
6 months. We're gonna get 6 months before I can. Yeah.
I had trouble spelling it.
No, okay.
Oh, yeah. You're here.
the record in the matter of the people of the state of Michigan versus Xavier Cleveland, file number 22-02760. Council appearance.
Brian Ring on behalf of the people.
Good afternoon, or good morning, Your Honor, Assistant Public Defender Stephen Feigelson.
Additionally, Adam Pfeiffer on behalf.
Apologize, Your Honor, Assistant Public Defender Stephen Feigelson, appearing on behalf of Xavier Cleveland, who's standing to my right, Your Honor.
Okay, so what's the date that was set for a preliminary examination and a PA 53 contempt hearing? Are we ready to proceed?
We are, Your Honor.
Are there any preliminary matters we should address?
Only that it will be both myself and Mr. Ring who is handling the examination. The plan is for Mr. Ring to conduct the questioning of Dayon Higgins, and I will be conducting the questioning of Destiny Higgins.
The only thing I'd ask would be a sequestration motion, given that there's going to be more than one witness in this matter. The other issue that I bring up, I think they're going to be calling Ms. Higgins' sister first, but she may testify at the trial if there is a trial. So I'd ask that she be not in the courtroom for Destiny's testimony.
Your Honor, that is not a requirement at all, because anyone who testifies before an examination would presumably testify at a trial, and the testimony at a preliminary examination would be in the transcript. They frequently find out if we got testimony before the trial. I'd ask that after Dayon Higgins testifies here, she'd be allowed to remain in the courtroom in support of her sister, who will be testifying afterwards, who is the named victim in this case. There is no requirement that anyone who potentially testified years down the road at trial be excluded once they have finished their testimony.
It's usually at a trial, not a preliminary exam. My concern would be is that she hears another testimony that confirms what she said on the trial.
Okay, so she's gonna testify, and then you're thinking that she's gonna change her testimony based on?
She could. I mean, I don't know.
Well, that could happen even if she wasn't sitting in here.
True.
You'd be able to impeach her.
She'll already have her testimony, which I think safeguards you on that, don't you think?
Good.
Yeah, I'm gonna deny the request for that purpose because her testimony is gonna be first. And I think that satisfies sequestration for that purpose. And I can't safeguard from any potential witnesses that may be called at trial. We don't know who's gonna be called at trial. I don't know.
Thank you, Your Honor.
Okay, any other preliminary matters?
Nothing else from the bench.
Okay, you can call your first witness.
People call Dayon Higgins.
Just so I'm clear, there's only one alleged victim, though, right?
Correct, Your Honor.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Okay, you can have a seat there. Okay, so there's a microphone that's right in front of you. See directly behind you is my court recorder. Her job is to take down everything that's being stated here today. So your responses must be verbal. They need to be loud and clear so that we can hear them even over these little plexiglass things that we have here. You can't do head nods and shakes because it's hard for us to determine that when we're writing that into the record, okay? Is that a yes?
Yes.
Okay, no, it's natural for people because people are used to saying mm-hms and ahs, reading yes or no's, or you'll hear me say, is that a yes, okay?
Okay.
Okay, also, if there's an objection, you would immediately stop speaking. I will make a ruling on the objection and then I would then tell you if you can give that answer or not, okay?
Okay.
Okay, can you state your first and your last name and spell both of them?
Want me to, like, say it individually or just?
You can say normally your first and last
Okay.
name and then you spell them both.
Dariana Higgins, Deriona, Higgins.
Okay, you can proceed, counsel.
Thank you. Is it okay if I call you Dayon?
That's fine.
Okay, Dayon, how do you know Destiny Higgins?
She's my sister.
And are you two close?
Very.
Can you describe that closeness?
I'm sorry. We just have that, big sister and little sister. They know each other about everything
They're frequent. Do you speak with her frequently?
for the most part.
About how many times a week?
Recently, every day.
Do you know Xavier Cleveland?
Yes, I do.
And how do you know Xavier Cleveland?
He's my nephew's father.
And if you saw him, have you seen him before?
Yes.
If you saw him today, would you recognize him?
Yes.
Can you please point to him and describe something he's wearing?
Blue.
Will the record reflect the witness's ID, please, then?
Any objection?
No, Your Honor.
Identification is noted.
Thank you. So we're gonna go back to October 12th. Do you remember what happened on October 12th
Of which year?
of 2022, sorry?
I woke up around 7:30. I checked I checked my phone and just sent me a text message that said, "Girl, how's you doing?"
And was that text message alarming to you?
Yes,
And why was that text message alarming to you?
because we have a code word and the code word is Lulu. That's my dog.
The code word is what?
Lulu?
Okay.
And why do you guys have a code word?
Because it's hard to explain, but essentially so that if something was happening between her and that I would be able to identify that without him essentially knowing that she was telling me something.
And do you remember when you established that code word?
It was probably 3 weeks prior or so.
And what types of situations would this code word be used in?
Honestly, situations where he was being violent.
Was that code word used on October 12th, 2022?
Yes, it was.
What did you do after you received that code word?
I called Destiny first, and then she didn't answer, so I called the police. Oh, wait, I'm sorry.
Go ahead.
I called my stepdad, and then
Why did you call the police?
because I couldn't get a hold of anybody,
What were you feeling when you couldn't get a hold of anybody?
I was scared.
And when you called the police, what'd you tell them?
I said, my sister well, first I called the Jackson Police Department, and then they transferred me to Anne County
Why, I'm gonna stop you for a sec. Why'd you call the Jackson police?
because I didn't know how to get to the Anne County.
Do you live in Jackson?
I live in Jackson.
Thank you. And then so they transferred you to Ingham County?
Mhm.
And then
Is
what-
that a yes?
Yes, sorry, yes, yes.
And then what did you tell them was going on?
I told them that I received a text message from my sister, that included the code word. I told them the code word was moving, and I was going to answer the phone. I don't live close enough to get to her in time, and I asked them to check on.
Did you stay on the line with them while they went to check?
They called, and I guess there were already police officers on site with her. They assured me that she was safe and that she was already speaking with police.
And did you let your sister know that you had called the police and they were on their way?
No, I don't remember. I don't think I did.
Nothing for this time, I think.
Prosecutor.
Yes, Your Honor, thank you. Good morning, Ms. Higgins. So
That's your sister, is that correct?
Yes,
Are you the older sister or is she the older sister?
I am.
And you said 3 weeks prior to this, you would set up a code word, is that correct?
That's correct.
Do you know if it had been used before that night?
No,
And you said you called Jackson Police who transferred your Lansing Police, is that correct?
that's correct.
And other than that, you did nothing else, is that correct?
That's correct.
And you said you've met your nephew's father, is that correct?
That's correct.
How many times have you met him before?
We've been together for years.
Okay, I got you. I have no other questions.
Redirect.
Very briefly, Your Honor. By your nephew, when you say your nephew's father, do you mean Destiny's father, of Destiny's children?
Yes,
And then you established this code word, Lulu. Was it only for Xavier?
yes.
It wasn't to be used in any other type of emergency? Thank you. Nothing further, Your Honor.
May this witness be excused?
No, I have one follow-up on that.
What do you mean? There's no cross to the redirect.
Yes, right, I apologize.
Thank you.
Yes,
You may excuse-
yes, Your Honor.
Okay, you may be excused from the stand, ma'am.
Thank you.
You can call your next witness.
Your Honor, at this time, the people would move to admit and publish to the court People's Proposed Exhibit 1, which is the medical report for the victim Destiny Higgins from the date of the offense. It is admissible without additional foundation and authentication under MCL 766.11B.
No objection, Your Honor.
Okay, people's one is admitted.
May I approach, Your Honor?
You may.
I'm standing outside.
May I approach?
Not space.
No.
Thank you. You can call your next witness.
Your Honor, the people called Destiny Higgins to the stand.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury? Okay, you can have a seat, ma'am. Okay, there's a couple of ground rules. There's a microphone that's in front of you, and I have a court recorder that's sitting right behind you. So she has to take down everything that's being stated today. You seem like you have a very light voice. So I'm gonna ask that you speak up as loud as you possibly can, okay? And all your responses must be verbal, so we can't do head nods and shakes or mhm and uhs. If you do, then just hear me ask you, is that a yes or a no, okay?
Okay.
Okay. And then if you, at any time you take a break, you can always request a break. If there's an objection, you would stop responding. I'll make a ruling on that objection, and then I'll tell you if you can give that answer or not, okay?
Okay.
State your first and last name and then spell both of them.
Destiny Higgins, DESTINY HIGGINS.
You can proceed, counsel.
Morning, Destiny.
Okay.
Do you know an Xavier Cleveland? How do you know him?
My son's father.
Were you also living together?
Yes.
I should know, we lived together on October 12th of this year.
Yes.
I was at 513 Hillsdale Street,
Yes.
apartment 2.
Yes.
I was that in Lansing and Ingham County.
Yes.
Now, would it be safe to say you would recognize Mr. Cleveland if you saw him again?
Yes.
You see him here in the courtroom today.
Yes.
Could you please identify where he's sitting and point to him so that we can identify him for the record? If the record reflection is pointed towards the defendant.
Any objection?
No, Your Honor.
So noted.
On October 12th, did you have contact with police officers?
Yes.
And did they talk to you at your home?
Yes.
Did you talk to them about an incident that happened with Mr. Cleveland?
Yes.
And did that incident just happen the night before and that morning?
Yes.
Now, if at any point you need a minute to catch your breath, please do not hesitate to say so. But what are you able to remember about that incident?
We were arguing. I went outside to calm down a little. When I came back in, I sat on the bed next to him. And he started unplugging my charger from the wall.
Your charge was up for your phone.
Yes. So I just got up and moved to a different part of the room. He followed me. Started unplugging my charger from where I was. So I tried to get up and move again. It started. He started masturbating and following me around the house. He cornered me by the bed. And he started pulling at my shirt.
Went off. What do you remember?
I tried to go across the bed to get away from him, but he pulled me down.
How did he pull it? Do you remember?
I just remember falling on my foot and feeling like it broke. And I remember him grabbing me by the back of my neck and pushing my face into the ground. I tried to get up.
Did he stop?
He had both his legs over mine, so I couldn't move. said, he said, you want sex, right? You want sex, right? This is what you wanted. I said, no, not like this, please, stop this. He forced himself inside of me.
You need to clarify, by inside of you, do you mean his penis inside of your vagina?
Yes.
And you were telling him you did not want this.
Oh, yeah, yes, I didn't want to. He told me to bend over on the bed. I told him no.
At some point, if you get a knife,
He said, oh, you think I'm playing with you? So we got over to the kitchen. And he grabbed the knife. He told me, if you don't listen to what I say, I'm gonna kill you.
can you point the knife towards you?
Yes.
Objection, I think it's a leading question.
I would be happy to rephrase it, Your Honor.
Objection sustained.
How was he holding the knife?
Like this.
If the record reflects, she was holding her arm up by her head in a stabbing motion. That was in your direction
Yes, and he kept lunging at me.
with the knife.
Yes.
What do you remember happening after that?
He told me to say, I'm Destiny. And I want sex. And that I'm a whore. And then he said he didn't want me anymore. So he laid down on the bed with the knife.
Did you try calling 911?
I personally didn't know. He took my phone,
Do you know why he took the phone?
so I wouldn't call 911.
How do you know that?
Because he told me that if he told me he wouldn't give me my phone back because he knows I'm a cop caller.
He called you a cop caller. Before we get any further, I do want to just make sure I've got this straight. I'm not confused. He had his penis inside of his vagina. He then stopped, went and got a knife. After he stopped and got the knife, he didn't reinsert himself inside. Go ahead. He made you say those things,
Yes.
and then he decided that he was stopping, and you were unable to call 911 because he took your phone away.
Yes,
Did you try and leave the apartment?
I did.
And what happened when you tried to leave?
So he said that because I'm a cop caller and he didn't want to go back to jail or prison, that it was over. And I asked him what that meant. He said that he was gonna kill me, call the police, and then kill himself so that our son would have somebody to take care of him
You say when this was going to happen?
in the morning.
When you tried to leave the apartment, did he do anything to physically stop you?
He chased me down the stairs with a knife. Told me to get my fat ass back upstairs.
He made you go back upstairs at knife point?
Yes,
At some point, were you able to briefly get your phone?
yes. After our son woke up,
Your son was there for this?
yes, he was in his room asleep.
How old is your son?
Um,
Did you message someone from your phone?
Yes, so after my son woke up, I tried to get some clothes on the both of us and get us out of the house. And he didn't want me to leave, so he gave me my phone back briefly. And I texted my sister a code word,
And what is your code word?
Lulu, her dog,
And what is this code word for? Why do you have a code word? Most people in their lives don't need to have code words.
because he's hurt me before. And I thought that it was a possibility that he might try to kill me. So to be safe, we put one in place.
And what was your sister supposed to do if you sent her this code word?
Either come get me or call the police.
Your Honor, I'd like to approach the witness's lips and mark as People's Proposed Exhibit 2. Yes, ma'am, I want you to take a look at this. Do you recognize the photograph in that exhibit?
Yes.
And what is that showing?
Text messages between me and my sister.
Does that accurately reflect the text messages you sent in regards to the code word that night?
Yes.
Your Honor, at this time, I'd seek to admit published Proposed Exhibit 2 to the court.
Any objection?
No objection.
Equals 2 is admitted.
Thank you, Your Honor. At some point, did police arrive at your residence?
Yes.
And this was on the morning of October 12th.
Yes.
What can you tell me about that? Police actually arrived at the place.
I was asleep when they came. I heard them knocking. And they woke me up, told me the police were outside and to not move and that he was leaving.
He told you not to move, not to go to where the police were.
Yes.
And so did he leave?
Yes.
How did he leave?
Through our back window.
He fled the location.
Yes.
Once he was no longer there around you, what did you do?
Tried to get to the door as quick as possible to get to the police.
Now, you said before that your foot had been injured and you thought it was broken. Did that present a difficulty to you actually moving and getting to the door?
Yes.
And you said they're knocking on your door. Are we talking about the front door to your apartment or the door to the building?
The door to the building.
And you were able to get there in time?
Yes.
You spoke with Officer Gregory Tracy, is that correct?
I believe so. Can't remember his name.
We spoke to a police officer
Yes.
from the Lansing Police Department.
Yes.
At some point later that day, did you get a medical examination done?
Yes.
Is that what's called a sane examination?
Yes.
No. Later that day, on October 12th, 2022, did you receive a call from Xavier Cleveland?
Yes.
And was this a call from the jail?
I believe so, but it was a three-way call.
Three-way call. What do you mean by that?
There was somebody else's number popped up instead of the jail number.
But you were speaking with Mr. Cleveland.
Yeah, at first I was speaking to somebody named Clarence.
But then you know you're speaking with him. You can
Yes.
recognize his voice
Yes.
based on your time together.
Yes.
What did he want to talk to you about?
He wanted me to not cooperate with police.
On this case?
Yes.
Did he say that he would do anything for you if you didn't cooperate with police? Let me rephrase.
Not in that phone call, no.
Let me rephrase. Did he say that he would not do things to you? If you,
Yeah, he said that. he would-
Objection, this is a leading question.
Do you want to respond to the objection?
I don't believe it's particularly necessary. I can rephrase.
Overruling the objection. He didn't give any information one way or the other. He asked if he said, would he do anything or would he not do anything? You can answer the question.
So, did he say that he would not do something to you if you didn't cooperate with police?
He said that he would stop calling and that he would leave me alone.
You have a digital exhibit. We could get. I don't know if the speakers on the laptop will be loud enough. I'd be happy to try.
There should be a cord that you can just link it into.
Person.
No, here's a spec. It's 'cause I'm so short.
Oh.
Call from.
Would you be able to recognize that call again if you were a part of it?
Yes.
Your Honor, the people would seek to play a portion of what's been marked as People's Proposed Exhibit 4. This call has been provided to defense counsel.
No objection, Your Honor.
Yeah, you can proceed.
I'm going to go
You said it
to,
was exhibit 4?
yes. I'm going to go to roughly 7.5 minutes. Kidding.
Can we please just do that?
That's all I wanted to do from jump.
Okay, and I'll do that. Can you just not do what you're, I don't know if you were talking to, I don't know. You put it on your dead grandma that you wasn't gonna be on nothing.
Hey, I did, and that's not the, and that's not a lie. I never called the police on you.
Hey, Destiny, look at here. I will assure you that he won't bother you. You feel me? I mean, I will assure you that, y'all be able to co-parent in peace. You feel me? I mean, it won't be no issues, no problems, you know what I mean? And so everything will roll smooth.
That segment I just played part of that call, that freeway call you had with Cleveland and Clarence?
Yes.
Your Honor, at this time, the people would seek to admit People's Proposed Exhibit 4 to this court.
Any objection?
No objection.
Exhibit 4 is admitted.
And I'll be seeking to publish this and play longer portion of this call later after Ms. Stickett's testimony. So from the court, he wanted you to not cooperate with this case, correct?
Yes.
He tell you not to testify?
Yes.
Thank you. A moment, please.
Yes.
I know we're also here for a P53 violation. If you'd like, I can take testimony as to that aspect right now. If there's a subsequent jail call, or if the court prefers, we can take it after the determination on these charges.
Nope, we can do so at this time.
Thank you. Now, that was on October 12th. Did you receive a subsequent phone call from Mr. Cleveland the next day, October 13th?
Yes,
And you know it was him from his voice, correct?
yes.
And what types of things was he telling you?
Leading question again, Your Honor, objection.
What types of things was he telling you?
I think he's
On a phone call?
spoon-feeding her what to, I think he's spoon-feeding her what to say. He's asking leading
Well, how else
questions.
is he supposed to question her? That was pretty open-ended. He received a phone call. What did he say?
I think that'd be more perfect than the way he's
Well, what
saying
kinds
it.
of things was he telling you? The same thing as what did he say?
Well, I just think the way he's saying it, it's leading-
Semantics, overruled.
What types of things was he telling you in that phone call on October 13th?
He said to be a woman of my word, not participate in court or with police. Told me that he would pay me any amount of money. Said he was sorry. He said that he fucked up.
Thank you. Here at this time, I'd ask the court to take judicial notice of the fact that Mr. Cleveland was arraigned early on October 13th with a no contact order in place, not to contact Destiny Higgins.
So noted.
Destiny, around what time was this call?
Around 7:30 at night, maybe a little later.
Now, was that a three-way call as well, or did you only hear his voice?
I only heard his voice.
Did you recognize the number that called?
No.
Thank you, Destiny. At this time, Your Honor, people have no further questions for this witness.
Cross exam.
Yes, Your Honor, thank you. Good morning, Ms. Higgins. I'm gonna turn back to October 12th. So your 4-year-old son and Mr. Cleveland were living together on Hillsdale, is that correct?
Yes.
And that night, your son and Mr. Cleveland were watching a movie, is that correct? Before the alleged events that happened earlier in the evening, you guys were all watching a movie, is that correct?
I don't recall, but we met.
Okay. You said you can't recall, is that correct? And at some point you put your 4-year-old son to bed, is that right?
Yes.
And did you tell Mr. Cleveland after you put your son to bed that you guys would play together? Have sex together?
I don't recall telling him no.
Okay. And then later in the evening, did you look at his cell phone?
His cell phone?
His cell phone, yes.
What do you mean? Did I
Did you go,
just look at it?
did you go through his cell phone that night?
I didn't go through it.
Did you question him about any calls or anybody he'd been hanging out with that day or the day before?
At night,
But other nights, is that correct, recently?
yes.
It isn't true you accused him of cheating on you?
Yes.
And that's what started this argument, is that correct?
No.
It's not correct?
No.
But you were mad, is that right?
It wasn't about cheating.
And you mentioned that you had set up a code word of your sister's dog, Lulu, is that correct?
Yes.
When, do you know when you set that up?
Maybe back in July.
Okay. Did you use another code word for anybody else?
No.
Did your sister use a code word with you for anything with her? Okay. And you said later that night, law enforcement or early the next morning came out, is that correct, on the 13th? You gave a statement to them, is that correct?
Yes.
And one of the female officers took you to the hospital, is that correct?
Yes.
And you said later in that day, you got a phone call from the county jail, is that correct?
Yes.
Do you know if as you got the phone call, if it mentioned it was recorded?
No. I didn't hear any of that.
Okay. And you had said that after the incident, you guys used the vape, is that correct?
Yes.
Was that for cigarettes or something else?
Yes.
Were you under the influence that night of any alcohol or any other substances that would impair your ability to remember anything?
No.
Your Honor, I have no further questions. Yes.
What was the argument about?
Sex.
In what capacity?
Um, I think the day before he told me to shave. And
Down there?
yes. Didn't say about anything, he just told me to shave, and so I did. And so I asked if we were going to, and he said no.
But by the time that he had you pinned on the bed, you were telling him no, right? Thank you. This time the people have no further questions for this witness.
Okay, and this witness may be excused. Correct?
Yes, Your Honor. The people have no further witnesses, but would seek to play for the court People's Exhibit 4.
Thank you, proceed.
No, Jackson.
Thank you.
I'm going to try and skip the unnecessary bits at the beginning about it being recorded.
Thank you.
Well, it would help.
Our job
Is not private. It will be recorded and may be monitored. If you believe this should be a private call,
Playing at the 2-minute mark.
facility instructions to register this number as a private number. To consent to this recorded call, press 1. To disconnect, press 2. Thank you for using Securus. You may start the conversation now.
Hello?
Hey, what's going on?
Man, shit with me and my BM, bro. And she just got me locked up.
I don't know, bro. I told you already, man. I mean, and you like you don't listen to shit I tell you, bro. It's like you got your own mind made up. You feel me? I mean, how can you still keep going back? I understand you love your son, but how can you keep going back to somebody that's gonna keep you locked up?
I don't know, man.
I mean, that pussy can't be that good.
It's not. It's just I want to be there for my son, bro.
I mean, man, you got to learn. You got to learn to be there for him on your own. You feel me?
Yeah.
Take your parenting time and be a good father. You feel me? I mean, sometimes it just don't work that way. I told you that when you first got her pregnant, bro.
Yeah. What's her name?
Feel me? I don't like that type of shit right there. A motherfucker to keep a motherfucker locked up. So what? You ain't got no bond, do you?
I gotta see the magistrate in the morning, or not in the morning, 1:30ish tomorrow. But hopefully though, I could walk out of here. I got a few warrants, which they said shouldn't be nothing major. But this new case, if it's just allegations, then I should be able to just walk free tomorrow. Because they said if there's no evidence of me doing anything, then you feel me, I'll be straight. But I don't know, bro.
Wow, bro. Damn, man.
Could you possibly talk to her, bro, and like tell her to stop, like just to stop? I'll leave her alone.
I mean, if you want me to, bro, I don't like people like that. You know what I mean? I don't care for people like that, bro. You feel me? Cause she playing with your life and your freedom and shit. That's just not what's up.
Yeah, I know. I just need you to talk to her. Just I know that she don't really know you or nothing, but just tell her like, look, I'll make sure because I got a job. I got a job, bro. And if I get booked, bro, I can't even work my job. And it's a 50 hour job, bro. It's a good ass job. Feel me? And I'm not trying to lose that because I was planning on moving in with you anyway, bro. If you was gonna let me, you know what I'm saying, and just working my job. Could you please just tell her like, look, I'll make sure he doesn't mess with you no more. Like, just stop doing what you're doing. There's no point to have him sent to prison. You know what I'm saying?
Right. Yeah, I most definitely do that for you, bro.
Like as soon as we hang up off the phone, please, bro.
All right, man, I got you.
Here, you ready for the number?
Yeah. What's the number?
808
808
800
800
5220.
5220. What's her name?
Destiny.
Oh, Destiny. Okay.
Actually, you think you can call her right now?
I mean,
because I don't got a no contact order.
I guess so. If you want me to, bro.
Yeah, please. Hello?
Yeah, hold on. I'm calling right now. I'm pressing it now.
All right.
Destiny?
Yes.
Hi, Destiny. I got Day on the line too. Is that okay with you?
Who is this?
This is Clarence, Destiny.
Hey, Des. You hear me?
What is it?
Look, I'm planning on moving in with Bird so I can start this job. I don't know if you cooperating with the police or whatnot. Just please stop. I just want to work. I just want to work and get my job. I ain't even started this job, bro. That's a good ass job. I'm not trying to lose it. I don't know if you're talking to the police or not, but please stop. I'm going to leave you alone. I'm not going to stay there, no nothing. I'm about to just live with Bird or my uncle, and I just want to work my job. Can we please just do that?
That's all I wanted to do from jump.
Okay, and I'll do that. Can you just not do what you're? I don't know if you were talking to. I don't know. You put it on your dead grandma that you wasn't gonna be on nothing.
Hey,
I did, and that's not a lie. I never called the police on you.
Hey, Destiny, look at here. I will assure you that he won't bother you. You feel me? I mean, I will assure you that y'all be able to co-parent in peace. You feel me? I mean, it won't be no issues, no problems. You know what I mean? And so everything will roll smooth.
Is that okay with you, Dad?
Yeah, because as of right now, I don't even want to look at you anymore, Zay.
Okay, that's good. That's good. I just please. Because it's a possibility if there's no evidence, I could go home tomorrow. You heard me?
Yeah, I heard you.
So please, I don't know what you're about to do. Just please don't do it. I will leave you alone. I'm about to just go ahead and go leave. I will leave. I really want to start this job. If there's no, they
And
said,
that's what I wanted for you. I wanted for you to start your job.
I know, and look, like I said, they've been telling me if there's no evidence, I'll most likely go home tomorrow. I'll get my stuff resolved, and I'll be able to walk free. I will have somebody come grab my stuff from the house, and I'll leave you be. Other than contact you for Kyrie, okay?
Perfect.
Can you put it on your diagram that you're not about to do anything?
Hey, look, she said perfect, bro. That's good enough. I mean, if she's a woman of her word. If she's a woman of her word, she's a woman of her word. She can't put it on nobody, on nothing. She said it. Her word should be.
Well, can I speak to Kyrie?
Because like I said before, Zay, I couldn't express it to you enough. I didn't want to see you in jail. Seeing you in jail for Kai's 4th birthday and seeing how hurt it made you and him and me, the last thing I wanted to see you was behind bars. I know what it's like to grow up with my dad in prison, and I never wanted that for Kai. I never wanted any of that to happen. So I literally was just in the car with your sister telling her, I don't want to cooperate with police. I don't want to go to court. I don't want to go to trial. I don't want to do none of that. I want you to get help, the help that you desperately need, and I want you to work on yourself so that you can be a better father to our son. That's what I want.
And I will. As long as I know that you're not going to, you feel me, do what you're trying to do. That's all I want to hear.
Do what, and I don't, why do you keep saying do what I'm trying to do? I didn't try to do nothing.
I don't know.
I didn't call the police.
Well, look, I just want to make sure we get this cleared out, and I'm just letting you know I will leave you alone. I'm going to leave. I'll get myself, I'm going to leave, okay?
All right.
Because, like I said, hopefully they said I could possibly leave tomorrow.
Hey, everything good, bro. She said, all right. You feel me? Hey, you don't have to, because you know that you know they listening in on these calls. Fuck all of that. You already said what y'all got to the point, to the major shit. Yeah. That's already out there is good.
All right. Well,
all right. Did you want to talk to Kyron?
Yeah.
You wanted to talk to?
Yeah.
Kai. Here, Dad's on the phone.
Hi, Dad.
Hey, Bubby, what you doing?
Good.
You doing good? Yeah. You been playing the game?
Yeah.
What you been playing?
This game, that game.
Okay. Look, I gotta tell you something, Bubby. You listening?
What? Yeah.
Dad's not gonna be at the house no more. Okay.
Okay.
I'll still see you though, okay?
Okay.
No, Dad loves you a lot, man. You know that, right?
Yeah.
All right. I love you.
I love you too.
Give me a kiss.
I wanted to let you know too that I was able to get his medicine today, just so you knew that was all okay.
We're getting mine.
Well, all right. I'm gonna let y'all go. Okay.
All right.
All right.
Bye.
Hey, hello. Hello. Yeah, I appreciate you, bro. Is you busy right now or something?
No, I'm just I've been split, but
I'm stopping it at 12 minutes, 37 seconds. And with that, Your Honor, the people request.
Thank you. Is the defense going to be admitting or calling witnesses today?
No, Nate, we have no witnesses for purposes of the exam, but can I get this back to Mr. Cleveland as well?
Okay, continue the argument.
Frankly, Your Honor, because a good amount was said today that wasn't included in the police report that was initially charged. There are a page of changes. Give me 2 minutes. I can hand you the page. Figure that one for you, one for defense counsel, and that will help as we work through this.
Thank you.
Yeah. Right here. But I figured happens to what yeah. Yeah. Okay. That's what you like. What's up? Yeah. Rip that off. See my pen. Yeah, also, no way, no one's reading that for me.
Yes.
Judge now, like, say, we should have sent you to med school.
Oh, your handwriting?
Copy.
Yeah. We just hand wrote 3 of them.
When I can scan this email too.
That'd be great.
Your pack, is it pack code on this one, the same one as that right there?
Yeah, that's what pack is.
These are the requests to add, or are you trying to amend them?
I will be changing the theories on counts 1 and 2, and then I will be adding a count 4, 5, 6, and 7.
Wait a minute, this should count for that. You have to count 2.
No count 2's unlawful imprisonment. That's the theory that's changing.
Oh, never mind, okay, sorry, I see the confusion, never mind.
I worked hard on this.
Yeah, never mind, I see where I got confused.
The people are ready at this point. So first and foremost, for count 1, I believe that it has been clearly met that a criminal sexual conduct in the first degree occurred here. However, the people are requesting a change in the theory of it. First, during commission of the felony of unlawful imprisonment and or felonious assault, I would seek to add and or a commission of domestic violence, third offense. I would also seek to add the force or coercion theory, and I would seek to take out the armed with the weapon theory, because as the victim testified to, the penetration happened before the knife. And as a result, that theory would not be appropriate given the testimony that was laid here. Second, for count 2, unlawful imprisonment, is currently charged under the theory of secretly confined and knowingly restrained. I would seek to change that to include theories of facilitating commission of felonies, that being CSC first, felonious assault and DV third, and or facilitating flight after the commission of those same felonies. as there are multiple instances of unlawful imprisonment that happened here, where he held her down on the bed in order to commit the rape, where he chased after her with a knife to get her to come back into the place, prevent her from fleeing and talking to the police, where he stopped her from just getting out of the apartment before, and even telling her, don't get out of bed the next day. Because there was such a wide range of him stopping her from leaving her own free will, I believe that each of these theories is appropriate. Count 3, assault with a dangerous weapon. He lunged at her with a knife in a stabbing motion multiple times and chased her downstairs, threatening to stab her and threatening to kill her. I believe that the elements for that have clearly been met. Which brings me to the requested added counts. First, I'll start with requested added count 4. That being witness bribery / intimidation / interference in a criminal case punishable by 10 years or more. The PAC code for that being 750.1227B. And I would seek a date range on that between October 12th and October 13th, due to the multiple jail calls that this defendant made to the victim, both before and after the no contact order was put in place by this court at its arraignment. And first, for bribery, he offered to give her something of value, not to continue to harass her in her life, which is something of value. Her safety, ongoing safety, is something of value. And he offered to give that to her in order to discourage her from attending as a witness, testifying, or giving information at an official proceeding. This and an eventual trial. He also encouraged her to avoid the legal process to withhold testimony. Secondly, for interfering with or trying to prevent her from being able to or willing to provide testimony at this hearing. And therefore, I believe it's appropriate under both the theories of bribery and under the theories of just straight interference. And this is a criminal case where the charges already were clearly punishable with more than 10 years. Unlawful imprisonment alone is a 15-year felony, and CSC first is a life offense. Therefore, I believe that is an appropriate additional felony charge based on the testimony and exhibits that we were shown today. Requested added count 5, interfering with a crime report by committing a crime. The PAC code for that being 750.483, A as in apple, 2, B as in bear. As the defendant, through the unlawful use of physical force, prevented or attempted to prevent another person from reporting the crime committed or attempted by another person, the violation included committing a crime, that crime being interference with a crime report, as he continuously took her phone away from her and prevented her from calling the police because, as he said, she's a cop caller and he's not going back to jail. Did I not say that? I apologize. The crime being interference in electronic communications by taking his phone. I apologize for the misspeaking there. As by committing the felony of interference in electronic communications, he was interfering with her from reporting the crime. But additionally, he said he was going to kill her the next day, which I would say is then under threatening to kill or injure a person or prevent them from reporting a crime. Lastly, count 6, domestic violence third offense notice. PAC code for that being 750.814. It is clear there was a domestic relationship. It is clear that he assaulted her. It is clear that she did not want to be assaulted, which meets all of our elements for domestic violence on the baseline. However, he has prior domestic violence convictions, that being of MCL 750.812, domestic violence first offense on October 24th, 2018. And then he has a conviction of MCL 750.813, that being domestic violence second offense notice on 12/3/2021. I would ask that carry over. Finally, requested added count 7, interference with electronic communications, 750.5405A. The defendant prevented or attempted to prevent the victim from using her phone and making an authorized telecommunication. He took her phone away from her. He told her explicitly why he was taking her phone away from her. She's going to call the cops. She's a cop caller, and he doesn't want to go back to jail. And then, when she was texting her sister for help, he took the phone away from her again. So I believe that the elements for that count have been met as well. It is clear from the testimony about what happened that day. Destiny was accurate. She was forthright. She was honest with everything about what she could remember from that day, even things that she might think doesn't help her, such as what the basis of the argument was. It was clear that she said no over and over. That he had to hold her down to insert himself inside of her. They threatened her with a knife. That he made her say degrading, demeaning things about herself. That he would not let her leave, would not let her call for help. I would ask that you bind over on the requested charges, Your Honor. Thank you.
I'm just still catching up.
Yep.
Oh. Okay. I recognize that you're actually requesting to add a domestic violence third offense notice. I just don't know if you offered any information for me to take notice of as it relates to his other.
Your Honor, that should not be needed as it's an enhancement, and even with an added charge of it, as long as I've dealt with this before. Normally with misdemeanors, you don't have to prove any of it, which is
I'm
technically.
not asking you to prove bias. I can take notice that he's been convicted previously of a domestic violence. I'm just been wondering, has he been convicted of?
He has, Your Honor. Because it's the enhancement, though, you don't need to prevent evidence of that. But he was convicted on those 2 dates of those 2 charges.
Okay, that would be the 10/24/18, and then there's a 12/3/21.
Yes, those are the MCLs above them for domestic violence second.
Okay, thank you. Okay.
Thank you, Your Honor. So I have to find a couple things why this case should not be bound over. I want to start with Ms. Higgins' testimony on cross-examination. I asked her if after they put their son to bed, if she had agreed to give Mr. Cleveland sex. She said she couldn't recall that. Yet she was vivid on every other detail. She couldn't recall that. When I asked her, she had gone through his phone. She said she couldn't recall that. When I asked her if they had been arguing about them cheating on her, she said she couldn't recall that. Yet she gives vivid details of everything else. But when I asked her 3 questions in regards to things that make her look bad, she said she doesn't remember. That goes to her credibility here today, Your Honor. Given all that, Your Honor, I don't think the elements can be met because the way I view this, she's saying that she wanted to give him sex, which isn't a crime, Your Honor. So I asked that none of these charges be bound over today.
She
Thank
didn't
you.
testify that she wanted to give him sex. You asked her. She didn't say.
She said she didn't. She doesn't remember.
Yeah, so how does that equate to testimony that she wanted to give him sex? When did that testimony come in?
Well, I'm taking that I don't remember to be.
Yeah, well, then that would make it a question of fact then, right?
Your Honor, she actually didn't say she didn't recall. She said no. She said she didn't recall as to whether they watched a movie or not and what the start of the argument was. But she said no, it wasn't about them cheating, and no.
My recollection is that the argument that was in her didn't say she didn't know was in regards to whether or not that was what the start of the argument. I definitely remember her giving testimony that would not lead me to believe that it wasn't that they weren't planning or thought they were going to engage in some form of intimacy, but that she's clearly testified that she said no, not like this. I believe what her testimony was. But do you have any other argument?
I do not, Your Honor.
Okay, today's the date that was set for preliminary examination At the time of preliminary examination, Mr. Cleveland, the burden is squarely upon the prosecution. It's their burden to establish sufficient evidence that probable cause exists, that a crime was committed, and probable cause sufficient to charge you with the crimes that they are alleging. And probable cause is more than just mere suspicion that a crime was committed. But it's not as much information as would be needed to prove your guilt beyond a reasonable doubt if this case is one that would be bound over and proceeded to trial. And the burden is a flexible burden. It's based on the testimony and evidence presented today at the time of the examination, and the court at the time is the sole determiner of credibility. And when determining credibility, a court can, or even a jury at the time of a jury trial, can either believe all, none, or some of what is being said. I recognize your attorney is making some arguments that because the victim seemed to have a cloudy memory about some of the incidences, that he believes that all of her testimony should be discredited. I would dispute that. I found her testimony to be credible. And as to whether or not she can remember things that she didn't believe were germane to this situation, I can't explain that, but I do believe that the testimony she did provide was credible. Now, whether or not there was enough testimony given to establish probable cause for the elements, the first count is count one, criminal sexual conduct in the first degree. And in order to prove that at the time of trial, the people would have to prove beyond a reasonable doubt first that the defendant engaged in a sexual act that involved entry into the genital area of or by the defendant's penis, finger, tongue. Any entry, no matter how slight, is enough. It does not matter whether the sexual act was completed or whether semen was ejaculated. Entry into the complainant's, in this case, based on the testimony, vagina, any entry how slight is enough. And the people are seeking to amend that under the theory to be charged on multiple variables. Again, one being the theory of commission of a felony of domestic violence third degree, and the theory of by force or coercion, without again rehashing the testimony in full. Ms. Destiny Higgins did give testimony today that on the date of October 12, 2022, at the area of 513 Hillsdale Apartment 2, located in the city of Lansing, Ingham County, state of Michigan, making venue before this court appropriate, that there was an incident that occurred in which she described an incident that it involved unconsented to sexual conduct by force and or coercion, and in commission of felony of domestic violence, as was indicated that the parties were in a dating relationship and had been in a dating relationship for about 9 years and shared a common child, and that the defendant at the time of the alleged incident resided with her. The court is satisfied that there's sufficient probable cause as to count one, and will be amended and bound over as requested by prosecution. Count two, unlawful imprisonment. At the time of trial, the people would need to prove beyond a reasonable doubt that the defendant knowingly restrained another person. Restrain means to forcibly restrict a person's movement or forcibly confine the person so as to interfere with the person's liberty without that person's consent or without lawful authority. The restraint does not have to exist for any particular length of time and may be related or incidental to the commission of other crimes. Second, the defendant did so under one or more of the following circumstances. A, the person is restrained by means of a weapon or dangerous instrument. B, the restraint person was secretly confined, which means to keep the confinement or location of the restrained person a secret, or C, the person was restrained to facilitate the commission of another felony or to facilitate flight after commission of another felony. The people are asking to find that over and then the theory to facilitate flight after felony of CSC first, domestic violence third, and felonious assault. I believe that based on the testimony evidence, there's enough to bind over as to the theories of either as requested by the prosecution or even as by means of a weapon or dangerous instrument, as there was testimony that there was a knife used to facilitate. So that will be bound over. Is there anything?
Yeah, Your Honor, frankly, I missed that. Of the whole page of changes, I missed the knife theory.
No worries, but they're sufficient to bind over as to that, so that will be bound over based on those theories. Count three, which was originally charged as assault with a dangerous and felonious assault, dangerous weapon or felonious assault in order to prove that at trial. The people will need to prove beyond a reasonable doubt first the defendant either attempted to commit a battery on Ms. Higgins or did an act that would cause a reasonable person to fear or apprehend an immediate battery. A battery is a forceful or violent touching of a person of another or something closely connected to the person. Second, the people will need to prove that the defendant intended either to injure Mrs. Higgins or to make Mrs. Higgins reasonably fear an immediate battery. Third, that at the time the defendant had the ability to commit a battery, appeared to have the ability or thought he had the ability. Fourth, the defendant committed the assault with a dangerous weapon. The testimony was that there was a knife used in the commission of the acts as testified by Ms. Higgins. So the court is satisfied that there is sufficient probable cause to believe that count three should be charged and bound over as well. Count four, or request to add count four, is for witness bribery, intimidation, interference with the criminal case. And at the time of trial, the people would need to prove beyond a reasonable doubt that Mrs. Higgins was an individual who was testifying or going to testify or going to provide information at an ongoing or future official proceeding. An official proceeding is a proceeding heard by a legislative, judicial, administrative, or other governmental agency or official authorized to hear evidence under oath. Second, that the defendant either gave or offered to give or promised to give anything of value. And third, or to the Mrs. Higgins. And third, that the defendant did give, offer to give, or promise to give something of value to Mrs. Higgins, or that he intended to from attending the proceeding, testifying, if she intended, or to discourage her from pretending to proceed and testifying at the proceeding, or giving information at the proceeding, or to influence testimony at the proceeding. Based on our testimony today and based on evidence that was submitted under People's Exhibit 4, we heard both testimony from Mrs. Higgins of one or two calls that were made to her asking for her not to cooperate with the police. Court also heard on People's Exhibit 4 a call in which there was a male's voice who the victim identified while under oath that was Mr. Cleveland's voice. And I think there was multiple requests made on that call for the victim to not cooperate, and that he would leave her alone, and that at one point I think there was testimony that he would give her any amount of money. I think she made that testimony that he would pay her any amount of money, and that he asked out if he would do that if she didn't cooperate. The court is satisfied that there's sufficient probable cause based on the testimony and evidence presented, and so count 4 will be added and bound over as well. Count 5, interfering with a crime report. There's a request to add that, and at the time of trial, the people would need to prove beyond a reasonable doubt. First, that the defendant prevented or attempted to prevent Ms. Higgins from reporting that the defendant had committed a crime. In this case, we have multiple actions here, but I think that the prosecution is requesting I guess it's just committing a crime. Second, that the defendant used physical force against Mrs. Higgins when preventing or attempting to prevent her from reporting the crimes. And then third, the defendant used a force involved committing or attempting to commit the crime of threatening to kill or injure a person or to threat to cause property damage. Ms. Higgins made testimony today that Mr. Cleveland at one point did grab a knife and order her back upstairs and said that he would kill her and kill himself, and called the police. And she also testified that he, while having the knife, chased her downstairs and told her to get her fat ass back upstairs. That he also took her phone and so that she could not call the police because he referred to her as, she quotes, a cop caller. The court is satisfied that there's sufficient evidence as to the request to add count 5, and that will be bound over to the circuit court. Count 6 of domestic violence, third offense notice. People have indicated that there's prior convictions from the defendant for domestic violence, those dates being October 24th, 2018, and then a conviction of domestic violence second offense on 12/3/2021. Based on the testimony today, there's sufficient probable cause to add and bind over as to count 6. Count 7 is interfering with electronic communications, that being telephone. Again, there was testimony from Ms. Higgins, that the defendant took her phone so that she could not call the police. Court is satisfied with the factual base. Satisfied with probable cause as to the facts presented on count 7. So counts 1 through 7 will be bound over as admitted. Your bind over date will be November 9th. You do not need to appear in court on November 9th, though. That's the date that they get the file from this court. The next court date will be in circuit court. It will be a pre-trial. You and your attorney will be made aware of that court date. Okay, sir? Okay, sir?
What's the date again? I apologize. I was talking to my.
It's a bind over date of November 9th. That's again just the date that they'll get this file from this court.
Yes.
Okay, and so we're gonna address your PA 53 in just a moment, but I want to make sure you don't have any questions about the bind over at this time. Okay. Okay, this matter was also set for a PA 53 violation hearing, also known as a bond violation hearing, because the allegations were that you made contact with Miss Destiny Higgins on or about October 13th, 2022 at approximately 1953 hours in violation of your no contact order. There was testimony about that communication today by Ms. Higgins. I think that was when she testified that you called and offered to provide for any amount of money if she did not cooperate, and that you effed up and you did not want her to cooperate. The court took judicial notice at that time that you had been arraigned earlier that day. That's indicated here in my court file. that you were arraigned on October 13th by Magistrate Milmore, that she did issue a PA 53 no contact order. And in that order indicates that you were not to have any direct or indirect communication with Destiny Higgins. And that you were not to assault, harass, intimidate, beat, molest, wound, or threaten Destiny Higgins, and that you were not to cause a third party to have direct or any direct communication with Destiny Higgins. We also heard a phone call today. And so did your attorney want to make any comments? Because I didn't really address the PA 53. Because I'm satisfied and I'm gonna sustain the violation. So you can make argument before I issue sentence.
Yes, Your Honor, a couple of things to point out. I know the court's already ruled, but the point I was gonna make is, we heard from Ms. Higgins that there was a call, but there's been no jail log, no recording, which is odd, because usually if there's a call made from the Ingham County Jail where she's saying the call was from, there would be a jail log or a recording. And to my knowledge, they can't produce that. What I understand, they're claiming that one phone in the jail that isn't recorded on Securus. I just find that hard to believe, Your Honor. Whether that's a secure facility, every other call I've ever received from the jail from one of my clients has been on a recorded line. So I find that hard to believe that there's one line that isn't recorded. She says what she said, but there's no direct evidence other than her word, Your Honor, and without any other evidence, I don't think it's enough to say it's a bond violation.
Okay, well, her evidence or her testimony evidence essentially amounted to the fact that she said that she received a phone call. When you cross-examined her and asked her, did she hear anything about whether or not it was recorded? Her response was that she didn't hear that, not that it wasn't stated, was that she said, I don't recall hearing that, that it was on a recorded call. We also don't know if this was a call that was made third party, and I heard testimony and saw evidence today of third party calls being made. So it's reasonable to believe that if she didn't hear that, it could have been that it was a third party phone call. I don't know, but she gave testimony today. I found her testimony to be credible. And so I'm sustaining it based on that. Did you want to say something?
Only as regards to the sentencing violation.
Okay, you can proceed.
I think his phone privileges need to be taken away. And I also believe his bond needs to be increased. It's currently $20,000 cash surety, given the charges he's facing and the conduct we have seen and what we have heard him say to the victim on the phone and then kept going. I think it needs to be increased to $50,000 cash surety, Your Honor. I think that and the removal of his phone privileges is appropriate in this matter. He has shown a willful disregard for the court's orders. We know that this wasn't unintentional or, oh, I didn't know, I didn't realize, no contact stopped me. Because in the call we heard from the day before his arraignment, he said, it's okay, I can talk to her. There's not a no contact order yet. He's been through this before. He knows the consequences of these actions, and it's clear what he was trying to do. So I think those are appropriate consequences for his actions.
Got a couple of things to point out with regards to the raising of the bond. I don't think it's appropriate, but the court's going to do what it's going to do with regards to the restricting of his phone privileges, Your Honor. I do believe that violates his due process. He does have a right to make contact to his family, Your Honor, if they want to block that number that is connected to Ms. Higgins. I'm supportive of that, but to restrict his entire phone privilege, I do think violates his due process and civil liberties. He would be entitled to make contact with his family if necessary, Your Honor. I don't think a complete restriction on his phone is appropriate today.
I think the part of the issue, okay, Mr.
I
Frank.
can visit him in person. He's forfeited the right to call people because he's calling people third party to violate the court's orders and commit further felonies. They can go and visit him in person. That's always an option.
I was going to say that based on the evidence presented today, sounds like Mr. Cleveland is using the phone privilege to call family or friends to do third-party phone calls. And so that is what the concern is. This is all happening. I mean, this is within weeks. Today is only the 27th, isn't it? It's all within weeks. I don't know that there's been any allegations of any further violation since the time of the 13th. I think that was the date of the alleged PA 53 violation. I also don't know. Well, I would imagine, based on Mr. Pfeiffer's past practice, that if there was any further violation, we would have heard about by now, and definitely on today. I'm not at this time going to restrict his phone privileges. I'm also not inclined to increase his bond, which is already set at $20,000 cash surety. He hasn't posted it, so I don't see why increasing it is going to address the actual contempt order, which is punishable with 93 days in jail and up to $7,500 in fines. And where I have a concern is where I don't have a situation where I have a individual who can make an argument that he was misunderstood or he didn't know that he couldn't make contact, because I heard testimony or evidence today that demonstrates an understanding of no contact order even before an arraignment. This is someone who's familiar or should be familiar with no contact orders, because there's at least 2 other domestic violence convictions on his record. And so I am going to find that he was in contempt of the court's order. He will be sentenced to 93 days in county jail for contempt. And you weren't posting bond anyway, so it probably won't do much for you. But I do want to send a message that there are measures in place for a reason, and you're not smarter than the system. And so you need to follow those rules, or else you're going to face consequences. And that's how we got here today. And hopefully there won't be any further violations. Hopefully there won't be any further calls or attempts to make calls and communications directly or indirectly with the victim. I'm going to, again, maybe break down what indirectly means, because it doesn't just mean calling someone else to have them put you on a 3-way phone call. You can't have anybody else send a message for you. You can't have anybody else slide in someone's DMs on your behalf, on the victim's DMs on your behalf, write a letter, smoke signal, none of the above. There's no communication directly or indirectly, not even in reference to your child. There's no communication with Miss Higgins. Do you understand that? No communication with Miss Higgins. 0.
So I can't talk to my son at all though?
No. I didn't say you couldn't talk to your son.
Oh.
You can't talk to Miss Higgins.
Yeah.
Okay? There's no communication with her at all.
Judge, I understand. I think he understands it, but the issue I think he's asking about is his son's 4 years old. He's going to be using the same phone as his mother. Obviously, there's got to be a way to parse that out. I just don't want to have an issue later when it comes up when he's calling that number.
He shouldn't be calling that number. He's not allowed to call that number because that's her number. It's not the son's number.
But the son's 4 years old.
That's not this court's problem.
Well, I understand.
That's the family court problem, but it's not this one.
Right. But how does
he can't call Miss Higgins' phone. You want to pay for his son to have a phone and have it dropped off there so he can call, then he should do that. But he can't call her phone, because what he would not want is for Mr. Pfeiffer to see him calling that number, because that would be a violation.
Right.
Yes, sir. If you have your attorney, if you want to speak, you have some rights that you should probably protect.
Okay, so my question is, say hypothetically I contact my mother and I just say to her over the phone, because I don't want to get in violation or anything. I thank you for not taking my phone privileges. What if I contact her, like, hey, can you get Kyron maybe this weekend or something? I would like for you to set up a video visit, or I would like to talk to you. Is that in violation?
No, that would not be in violation, because you're calling your mom because you want to talk to your son. So your mom is not calling the victim to talk about on your behalf to talk to her. She's calling to talk to the son, and then that could be arranged. And I'm sure they probably already have arrangements. I wouldn't constitute that a violation. Any other messages though about that you want delivered to the victim would be a violation. But having your mom call to schedule visitation or to schedule a phone call is not a direct violation of this bond, okay?
May I speak again?
Absolutely.
Another thing, is it any way that I can present evidence? Okay, well, last time I served a year or served a year for my domestic violence against Miss Higgins, she had contacted me via e-messaging. Is there some way if she does do that, I can report that and that be something
You
that
can absolutely report it. You should talk to your attorney if she does reach out to you, okay? And then he will make sure that's properly addressed.
Here's what I'm gonna do. If she emails you, save those emails, but do not want you to respond.
Exactly. If you respond, she's not gonna get in trouble, you are. Now you get it?
Yes, sir.
Any more questions?
As of currently, no.
Okay. Any additional matters for the record, counsel?
Not from the people, Your Honor.
Not from the bench, Your Honor.
That bond will continue. You're
Thank
all
you.
set. Here's your exhibits.
Thank you. You got your left.
When it's marked, it's sticker.
If we can get a copy of the transcript.
I'll come outside a bit over the phone. My laptop is no longer on the version of death.
Thank you.
You're welcome.
I don't know about putting this note in. I have to staple your note in here.
What?
I am not writing all of this.
Thanks, man.
What?
Yeah, I'm copying it into the case notes.
Oh, okay.
Whenever you
I think
change
Adam-
any
Charges.
charges.
You're gonna give us a new
Yeah,
complaint at this point.
yeah, no, we're gonna have to write up a new one.
Yes, you are.
Let's see.
And the problem is, the police report genuinely didn't reflect